scenario. Number 44, weeks time.
44.
44.
I represent the petitioners.
New petitioner. What about that?
2 weeks, my lords may say.
2 weeks.
There's an
At the
interim
request
order
of-
that we.
So interim order to find.
My lord, serial number 38 and 39, my lord.
Huh?
Serial number 38 and 39, my lord.
28, 29.
Final hearing.
28, 29.
38 and 39. my lord.
38, 39.
But I have an inconvenience because I'm shifting my office. I don't have a.
Okay. When do you want?
The week next.
All right.
We take.
Next week.
Week after.
Week next week.
Week after next. Week after next. At the request of. All right. Interim order ಇದೆಯಾ? ನೋಡ್ಕೊಂಡು ಹೇಳಿ. Okay.
Serial number 43, my lord.
ಹಾ.
A week's time, my lord.
43.
My lords.
All right.
For the petitioner, my lords.
43.
Interim order to be extended.
All right.
Your lordship, serial number 30.
ಏನು?
Raise 2 weeks time, your lord.
ಯಾವುದು?
Serial number 30.
ಪೂರಾ ಹೇಳ್ಬೇಕು ಸರಿಯಾಗಿ. Serial number
Serial number 30, please.
30.
Yes, your lord.
ಮತ್ತೆಲ್ಲ ಕೊಟ್ಟು ಮುಂದೆ ನಾವು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ?
Yes.
ನೋಡೋಣ ಇರಿ ನೋಟಿಸ್ ಆಗ್ಬೇಕನ್ನ ಅದರಲ್ಲಿ.
Connected matter adjourn ಆಗಿದೆ some 2 weeks ಇದಾಗಿದೆ. Connected matter yesterday ಇತ್ತು.
ಯಾವ್ದದು?
Yesterday ಇತ್ತು ಸ್ವಾಮಿ. 502.
ಬರ್ದು ಕೊಡಿ. ಎಲ್ಲ ಅರ್ಧ ಮಾತಾಡ್ತಾ ಇದಿರಲ್ಲ. ಪೂರಾ ಮಾತಾಡೋದೇ ಇಲ್ಲ. ಬರ್ದು ಕೊಡಿ. Call this matter along with. Okay.
Please.
Serial number 34 and 36 2 weeks.
34.
36.
34, 36, 2017, no, sir.
Senior Mr. Shankar.
As
the
senior
week out
really
of
answer,
September.
ಬಂದ್ರೆ ಅಕ್ಕಿ ಹೇಳ್ತೇವಿ, ಇಲ್ಲ ನಮ್ಗೆ ತಿಳಿದಂಗೆ ಬರ್ದಾಗ್ತದೆ.
On third date, madam, next week, madam.
Reluctantly adjourned by 1 week on request of counsel for the petition.
34 and 36.
34, 36. Okay. Next.
Serial number 35, my lord. For the appellant, arguing counsel is unavailable today. By 2 weeks,
Matter. 6 ವರ್ಷ ಆಗಿದೆ.
my lord.
ಏನು
Just by 2 weeks, we will certainly, 35,
2 weeks.
much obliged.
Reluctantly adjourned by 2 weeks ಅಂತ ಬರೀಬೇಕು. Old matters ನಲ್ಲಿ. 32. Admission matter. All right. Yeah, are you not happy with this bench or what? ಇಷ್ಟು ಜನ ಟೈಮ್ ತಗೋತಿರಲ್ಲ ಯಾಕೆ? ನಾವು ಸರಿಯಾಗಿ ನಡೆಸಲ್ಲ ಅಂತನಾ ಏನು ಹಂಗೇನ್ರ ಇದ್ರೆ ಹೇಳ್ರಿ ಸ್ವಲ್ಪ ನಾವು ಸರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಪ್ರಯತ್ನ ಮಾಡ್ತೀವಿ. All right. 2 weeks at the request.
Serial number 21, my lord.
21.
Yeah, it's for serving the copy to the other side, government advocate. We'll do it in a week's time. There is some complaints also for translation.
ಏನ್ ಬೇಕಿಲ್ಲ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಇಬ್ಬರಿಗೂ ಕನ್ನಡ ಬರುತ್ತೆ. ಆರ್ಗ್ಯೂ ಮಾಡಿ.
My lord,
20 matter.
2 weeks.
No,
Senior has to
next.
come, my lord. He has
Yes,
some
sir.
inconvenience. My
Madam,
lord,
serial number 41.
a
madam.
week's time, my lord.
41, my lord.
Next.
Madam,
ನಾವು
serial number
ಕೆಲ್ಸ
41, my lord.
Please, my lord.
ನಾವು ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದೇವಿ ಇಲ್ಲಿ. Time
41, my lord.
ನಾವು ಅಪಾಯಿಂಟ್ ಮಾಡಿಕೊಂಡಿದ್ದು to adjudge case to do justice according to law, not giving adjournment.
Madam, serial number 41, my lord.
Next. One. ಟೈಮ್ ತಗೊಂಡು ಕೆಲಸ ಮಾಡಲ್ಲ ಏನಿಲ್ಲ. ಬರೀ ನೆಕ್ಸ್ಟ್ ಕೆಲಸ ಮಾಡ್ಬೇಕು. ಲಾಯರ್ಸ್ ಎಲ್ಲ ಸರಿಯಾಗಿ ಕೆಲಸ ಮಾಡ್ಬೇಕು. ಟೈಮ್ ಕೊಟ್ಟು ಹೊಡ್ಕೊಂಡು ಹೊಟ್ಬಿಟ್ರೆ ಕರೆಂಟ್ ಗತಿ ಏನು ನಮ್ಗೆ ರೆಸ್ಪೆಕ್ಟ್ ಸಿಗಲ್ಲ. ಬರೀ ಅಡ್ಜರ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ ಇವ್ರು ಜಡ್ಜ್ಗಳು ಉಪಯೋಗ ಇಲ್ಲ ಅಂತ ಜನ ಮಾತಾಡ್ತಾರೆ. ನೀವು ಮಾಡೋ ಕೆಲ್ಸಕ್ಕೆ ನಾವು ಹಂಚಲಿಕ್ಕೆ ತಯಾರಾಗಲ್ಲ. ಎಸ್
Sir, I appear for the petitioner, my lord. Lord, the Honorable Special Court, my lord, constituted under the Land Grabbing Prohibition Act. Lord, on the complaint given by the villagers, petitioners are the villagers. Lord, adjudged the second respondent as the land grabber. Lord, wherein the second respondent, Lord, has constructed a 4-storied commercial building and has let out to some to various persons and deriving income therefrom for the last few years. Lord, after the my lord, in the impugned order, my lord, only he has been convicted, my lord, but the further consequent orders as provided under section 9(8) of the Land Grabbing Prohibition Act has not been passed, my lord. Only that is the factual position. Lord, this
Come
one,
to page 33.
pardon, my lord.
Page 33 ಬನ್ನಿ. Operative portion ಓದಿ.
Yes. May I read, my lord?
Yes.
Acting under section 255(1) of the Code of Criminal Procedure, the accused in LGC number 1287 of 2018 and 1289 of 2018 are acquitted of the accusation brought against them. So
Yes.
that it is relating to others, my lord.
Yes.
But acting under section 255(2) of the Code of Criminal Procedure, the accused in LGC 1372, my lord, where I am concerned, of 2017.
Convicted.
Yes, are convicted of an offence punishable under section 192A(1) of the Karnataka Land Revenue Act, and they are sentenced to suffer imprisonment for a term of 1 year and to pay a fine of ₹5,000 each, and in default to pay the fine, to suffer imprisonment for a term of 3
After
months.
conviction order,
Yes, ma'am.
there should be an order for removal of encroachment appears to be.
Yes,
given.
ma'am. The government
Which is
should-
that section?
Pra-
Which is that section?
Regular 39 of the regulation.
What? Land grabbing.
Yes, ma'am.
Section 9(8), subclass 8.
9.
Section 9, subclass 8.
That is for or other relief.
Court to pass an order. Section 9(8).
I will come to you. Please be seated. We will not pass any order without hearing. Yes,
Regulation
Mr. Hebbar,
30
ಯಾವ section ಓದ್ಬೇಕು ನಾವು?
Regulation 39, my lord. Procedure for taking possession,
1 second. 30.
39, regulation 39.
ಏನ್ ಪೇಜ್ ಅದು ನಿಮ್ ಬುಕ್ ನಲ್ಲಿ?
ನಮ್ಮ ಇದರಲ್ಲಿ page 41. May I pass on this?
ಬೇಡ ನಮ್ದಲ್ಲಿದೆ ನಿಮ್ book ಬೇಡ. Regulation 2017
ಹೌದು. ಅಲ್ಲ, regulation 39
of
of the Karnataka land grabbing regulation.
which year? ಪೂರ ಮಾತಾಡ್ಬೇಕು. ಎಲ್ಲ ಅರ್ಧ ಅಲ್ಲಿ ಸೆಟ್ ಆಫ್
17 ಒಂದು.
2017
ಹೌದು.
regulation number
39 madam.
procedure for taking possession. The special court shall communicate its final decision or order in respect of land to the affected parties and also to the right officer to give effect to the decision. The shall on receipt of the order of the court issue arrange to issue direction in function deputing any officer not below the rank of inspector take possession of the grabbed land on behalf of the internet to the person of the copy of the authorization in position of occupation of the grabbed land delivers possession voluntarily. The officer to deputed under substance shall record a statement of the person where the person in position of the fails to deliver or so deputed certificate. Now show that the conviction is for the offense of land grabbing.
Land grab.
So land was encroached, number one. The encroachment continues even as on the date the conviction was entered. Where is that finding?
Lord, this honorable court directed the Tahsildar to file a report on this aspect, my lord. The
The finding ಎಲ್ಲಿದೆ? Court the finding ಬೇಕಾರೆ. See, offense, for example, we'll give you one example now, which
Yes.
we find in Kenny's outlines of criminal law.
Yes, ma'am.
Suppose the thief is found, thieved article is found, the article is taken back. The theft does not come to an end. He
Yes.
will be prosecuted. But there need not be order for delivery of the thieved article under 451, 457 of CRPC. Where is the finding that even now he continues to be in unauthorized occupation of the public land? ಅದೆಲ್ಲಿದೆ? Painting ತೋರ್ಸಿ.
Therefore, my lord, I wanted to draw the attention of this honorable court to the affidavit filed by the Tahsildar after the passing of this order.
Where is that?
My lord, pursuant to the order passed by this honorable court, Tahsildar has filed an affidavit on 19/4/2022. That is on record, my lord.
19/4/2020. You are right. Natesh.
Yes, Mr. Natish. My lord, may kindly peruse paragraph number 3. May I read, my lord?
What happened to that 48058 of 2019 is another matter. What
Another
happened to
matter,
that
sir.
matter?
Another matter, my lord, in fact, I am not a party to that.
That's all right. What happened to that matter?
But that matter, my lord, it is pending, my lord.
It has been regularized when? 20, after the order. After you were found encroacher.
And it is now, my lord, being approved by
ಕೊಡಿ.
I have a Xerox copy, my lord.
ಹೆಂಗ್ ಕೊಡ್ತಾರೆ ಕೋರ್ಟಿಗೆ ಕೊಡುವಾಗ?
Memo.
This is not a tea shop. We are repeating the words of Honorable Chief Justice of India. This is, court is not a tea shop. There should be a method. Warning, ಮೆಮೊ ಹಾಕಿ ಕೊಡ್ಲಿಕ್ಕೆ ಎಷ್ಟು ಟೈಮ್ ಬೇಕಾಗ್ತದೆ? ಕೊಡಿ. ಎಲ್ಲ ನಿಮ್ substandardness should not be reflected in the court proceedings. ಕೊಡಿ, 4 ಜನ ನೋಡ್ತಿರ್ತಾರೆ. What kind of proceedings? Not a tea shop. ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಎಲ್ಲ ರೂಲ್ಸ್ ಅನ್ನು ಓದ್ಕೋಬೇಕು. ಹೈಕೋರ್ಟ್ ಪ್ರೊಸೀಜರ್ ರೂಲ್ಸ್ ಇದೆ, ಅವನ್ನೆಲ್ಲ ಓದ್ಕೊಂಡ್ರೆ ಸರಿಯಾಗಿ ಬಿಹೇವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಕೋರ್ಟ್ನಲ್ಲಿ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಮಿಸ್ಬಿಹೇವಿಯರ್ ಆಗ್ತದೆ. ಯಾವುದೇ ಕಾಪಿ ಕೊಡುವಾಗ ಒಂದು ಮೆಮೊ ಹಾಕಿ, ಆಮೇಲೆ ಅಪೋನೆಂಟಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟು, ಅವ್ರಿಗೆಲ್ಲ ಹೇಳ್ಬೇಕು ನೀವು ಹೆಬ್ಬಾರ್ ಎಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ಗೆ ಯು ಶುಡ್ ಟೆಲ್ ದೋಸ್ ಥಿಂಗ್ಸ್.
Yes,
ಹೌ
Milord.
ದೇ ವಿಲ್ ನೋ. ನಾವ್ ಇಟ್ ಇಸ್ ಓನ್ಲಿ ವಾಟ್ಸ್ಆಪ್ ನೋಡ್ತಾರೆ ಹೊರತು ಯಾರು ಬುಕ್ಸ್ ಓದಲ್ಲ ಏನಿಲ್ಲ.
Milord, in fact,
ಅವ್ರಿಗೆಲ್ಲ ತಿಳಿಸಿ ಹೇಳ್ಬೇಕು ನೀವು.
Milord, in fact, in my office, Milord, every day, almost every day, I say that the decorum is to be maintained, how it is to be conducted.
Now, your friend is saying
Yes, sir.
it has been regularized under a statute.
Yes,
It's a nova causa intervenus, new cause of action. You should challenge this.
Milord,
Then you can make
Milord,
that
in
order.
so far as that his case is concerned, I am not a party.
Who is
to the
he?
proceedings. The second petitioner, Milord, in the other LGC number.
He is not convicted.
Yes,
He
I
is
can-
also convicted.
Yes, on a different complaint, not against my this thing. How?
Yeah, are you a party in this proceeding now? In this petition, are you a party? You are not a party. Please be seated. ಇದರಲ್ಲಿ ಪಾರ್ಟಿ ಇಲ್ಲ ಅವ್ರ ತಾನೆ?
ಇಲ್ಲ.
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 ಯಾವ ಪ್ರಾಪರ್ಟಿಗೆ ಇನ್ನೂ ಎನ್ಕ್ರೋಚ್ಡ್ ಪೋರ್ಷನ್ ಯಾವುದು ಹೇಳೋದು?
Milord, that is in survey number 1/P1.
1/P1.
ಹೌದು.
Where is the finding by the special court?
Paragraph 17, my lord, may kindly peruse. Milord. 18 is the relevant paragraph which my lord has asked me the question.
Yes.
18.
Government line to the extent of 29 into 16 feet. So and so in survey number 1 of Manjenahalli, Kaval.
Yes.
With an intention of holding it and have constructed a shop, residential house, shop, hotel, etc. So, which respondents, which accused?
Chennai Gowda, my lord, in 1372, case number 1372, Chennai Gowda, my lord, and the cost title.
1372
Yes, my lord.
of 2017.
Exactly.
Chennai Gowda is which respondent?
Chennai Gowda is second respondent in.
Who appears for Chennai Gowda?
I represent.
Yes. What do you say about
Not
this?
my submission. A deed petition is not maintainable. Because, Lord, if any order passed under section AS9, and there is a review under section 16, there is a provision, Lord, specifically section 9 subclass 8 says, if not the court, convicting court commitment, any mistake, it can be rectified under section 16. Lord, instead of appearing before this Honorable Court, Lord, yes, I has to approach with the same court for, it is permissible under the law also, section 9 subclass 8 specifically deals the issue. If there is no order for redelivery of the possession, the court has got a power to, Lord, to rectify that order passed in section 8 and under section 16. For a moment, for kindly see, Lord, section 9 subclass 8.
9(3).
Please, Lord. Section 9 subclass 8, Lord, for a moment. The act, Lord. Land grabbing act, 2011.
9(3).
9(8).
9(8).
Please, shall I read, Mila?
Once.
Please.
Provided that the special court shall, by notification, specify the fact of taking cognizance of the case under this act. Such notification shall state any objection which may be received by the special court from any person, including custodian of the vacant property within the period specified therein shall be considered by you. Provided further, where the custodian of the vacant property objects to special court taking cognizance of the case, court shall not proceed further with the case in regard to such property. Provided also a special court shall cause a notice of taking cognizance. Section 9.
8, Mila, 8.
8. It shall be lawful for the special court to pass such order as it may deem fit to advance the cause of justice. It may award compensation in terms of money. Wrongful possession grab shall not be less than the amount equivalent to the market value of the land grab as on the date of the order. Profits accrued should be payable with the grabber to the delivery of grab land to its site. The amount of compensation shall be so awarded for children shall be what as an arrears of land in case. Any case will be executed with a special court.
Either.
Special court shall, before passing an order under this subsection, Land grabbing, opportunity of making the representation of the alleged evidence in any of the part considered authorized.
It is in the
It has
form,
not been done, therefore he is here.
section 16 for a moment.
1/6,
Oh, 17, 1/7, review,
1/7.
1/7. If any order passing section 9,
1 second.
please, section 17. 17 of the same act.
The special court may, in order to prevent
Prevent-
miscarriage of justice, review its judgment of the past. But no such review shall be entered in acceptance. Now, where is that? Review is held, no, sir, no alternate remedy. When I 84 KLJ,
Please, not, but section, like, my
we
submission.
are asking, are you are in the occupation of?
No, man, I am already, the portion was.
When did you hand over? Show that.
That one,
That's all.
only one copy, man, they handed over to me while taking possession.
You say land is handed over. You
Handed
say you
over.
have only one copy to hand over.
Only this.
Which
road-
handover we have to hand here now?
Tahsildar, not Tahsildar has to.
Who is the Tahsildar? Has he taken possession of the property?
My lordship, we have
When?
taken, we have filed the report also, my
Where is
lordship,
that?
on 19/4/2024.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ?
Yes, we had, no, we had served it.
You have sold the copy. ತೋರ್ಸಿ.
19/4/2024.
That's what my lord has
Previous we
referred
had-
to it now.
We had filed an
Affidavit.
affidavit, my
That is,
lordship.
affidavit.
Based on the affidavit, this honorable court had.
You have taken possession of the property.
Please, my lordship. it
When
is
did
a-
you take the possession?
That is on 6/4, my lordship,
6/4.
2024.
Where have you stated? Sixteen, 6/20/24 ಈ ಪೊಸಿಷನ್ ತಗೊಂಡಾರೆ ಅವರು. ತಗೊಂಡಿದಾರಲ್ಲ, ಇನ್ಫ್ಯಾಕ್ಟ್ ನೀವು ರಿಟ್ ಹಾಕಿದ ಮೇಲೆ ತಗೊಂಡಾರ ಅವರು.
Subsequent.
ಎನಿವೆ, ಪರ್ಪಸ್ ಇಸ್
ಇದು-
ಸರ್ವ್ಡ್ ನೌ.
ಎಲ್ಲ ಇದರಲ್ಲಿ ಅವರ ಅಫಿಡವಿಟ್ ನಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಮೇ ಐ ಪಾಯಿಂಟ್ ಔಟ್ ಮೇಡಮ್, ಇನ್ ದ ಸೇಮ್ ಅಫಿಡವಿಟ್ ಆನ್ ಪೇಜ್ ನಂಬರ್
ಪ್ಲೀಸ್ ಕಮ್ ಟು, ಅದು ಬಿಡಿ, ಅಫಿಡವಿಟ್ ಬಿಡಿ. ಕಮ್ ಟು 6/4/2024 ಮಹಜರ್.
ಕಾಪಿ ನಮ್ ಕಾಪಿ
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ, ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ. Otherwise, I would have directed his arrest and detention.
Yes.
ತಗೊಂಡ್ಬಿಟ್ಟಾರು.
Yes. ಐ ಜಸ್ಟ್ ರೀಡ್ ಮಾಡಿ ಒನ್
ಆಯ್ತು, ನೋಡಿ. ಅನಧಿಕೃತ ವಾಣಿಜ್ಯ ಕಟ್ಟಡವನ್ನು ಭೂಗತ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ರೀತಿಯ ದಿನಾಂಕ 16/22 ಸರ್ಕಾರದ ಸುಪರ್ದಿಗೆ ಪಡೆಯಲಾಗಿರುತ್ತದೆ. ಈ ಕೂಡ ತಹಶೀಲ್ದಾರ್ ಹಾಸನ ಮತ್ತು ಹುಬ್ಳಿ ರಾಜ್ಯ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಕಳುಹಿಸಲಾಗಿದೆ. ಇನ್ಫೆಕ್ಚುಯಸ್
ಬೈ ದ ಡೆಪ್ಟಿ ಕಮಿಷನರ್.
ಬರ್ಕೊಳ್ಳಿ.
The copy.
Lord,
ಅಷ್ಟೇ ಕೇಸ್ ನಿಮ್ದು.
only grievance, my lord, is that he has been in possession for 17 years.
ಅದಕ್ಕೆ ಬೇರೆ ಏನಾರ ರಿವ್ಯೂ ಹಾಕೊಳ್ಳಿ, ಅಲ್ಲಿದೆ ನೋಡಿ. ಅವ್ರು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ ನಮಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ ಅದು. ಯು ಕ್ಯಾನ್ ವಿಲ್ ಲಿವ್ ದಟ್ ಲಿಬರ್ಟಿ ಟು ಯು.
Yes, yes,
ಬರ್ಕೊಳ್ಳಿ,
yes,
ಕೂತ್ಕೊಳ್ಳಿ. ಪ್ಲೀಸ್ ಬಿ ಸೀಟೆಡ್.
grateful.
The short grievance of the petitioners who happen to be complainants before the land grabbing court, ಸರಿಯಾಗಿ ಬರೀಬೇಕದ್ನ, is as to no steps being taken for retrieving the encroached public property on which a building does exist. First, learned counsel appearing for the petitioners submits that once an order of conviction and sentence is entered after holding due trial, there has to be a consequential direction for retrieving the public property, as per the policy content of the Karnataka Prevention of Land Grabbing Act, etc., 2011. First, this having not been done, council submits, the impugned order to that extent is vulnerable for challenge. First, next one. After service of notice, the official respondents are represented by the learned CGP, Srimati so and so. The answering private respondent is also represented by a private advocate. First stop. Our attention, next paragraph. Our attention is drawn to certain documents produced wide memo dated, date ಬರೆಯಲ್ವಾ ಮೆಮೋಕ್ಕೆ? ಡೇಟ್ ಬರೆಯಲ್ವಾ ಮೆಮೋಕ್ಕೆ?
It is on the first page.
ನಾವು ಅದಲ್ಲ, ನಿಮ್ ಡೇಟ್ ಇಲ್ಲಿ ಬರಿಬೇಕು, ಅದು ಫೈಲಿಂಗ್ ಇದ್ದು. Dated, ಯಾವ ಡೇಟ್ ಅದು?
19/4/2024.
Dated 19/4/2024, which reads, ಏನ್ ಬರ್ದಮ್ಮ? Produced, read that sentence. First off, one of the documents, namely the letter dated 6/4/2024, addressed to government advocate, is to the effect that the property, the subject property has been retrieved to the government along with the structure existing thereon. First off, the same reads as under. Next paragraph. In the above circumstances, the purpose of this writ petition is largely accomplished, and therefore the same needs to be disposed of as having become infructuous. First stop. However, liberty is reserved to the petitioners to take appropriate action for recompense or the like, as provided under the provisions of Section 9 of the 2011 Act. First, in that connection, all contentions are kept over. Parts made easy. Who are you? Why did you interfere in this case? You were not a party. That's all right. In this case, you are not a party. In connected to Christian, you are a party.
Connected, it is a separate.
ಅದು ಪೋಸ್ಟೇ ಆಗಿಲ್ಲ, ಅದು ಆಗಿದೆ.
1.1
ಸೇಮ್ ಆರ್ಡರ್ ಆಗ್ತದೆ, ಬರ್ಕೊಳ್ಳಿ. ಇದು ಬೇರೆ ಆಗ್ತದೆ ಬಿಕಾಸ್ ಆಫ್ ರೆಗ್ಯುಲರೈಸೇಷನ್. ಬರ್ಕೊಳ್ಳ. By and large, the facts of this petition are substantially similar to those involved in WP 9334 of 2019, which we have disposed of this day by a separate order. First off, suffice it to say that pursuant to order of conviction and sentence that is put in challenge, WP other criminal appeal madira challenge in criminal appeal number 2024 of 2018, counsel for the petitioner submits, the encroached public property was liable to be retrieved, and that having not been done, petitioners are knocking at the doors of writ court. First stop. Next paragraph. After service of notice, official respondents are represented by the learned HCGP, and the private answering respondent is represented by a private counsel. Respondent is represented by a private counsel. Allah. Private respondent illa. ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡೋದು ಬೇಡವಾ? ಮಾಡಿ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ನೀವು. ಈಗ ಯಾವ ಪ್ರಾಪರ್ಟಿ ರಿಸ್ಟೋರೇಷನ್ ಕೇಳ್ತೀರಿ, ಅದು ಯಾರ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೆ?
Second respondent in my
ಇಲ್ಲ, ಅದು ಹೋಗ್ಬಿಡ್ತಲ್ಲ. ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅವರು.
It is his, it is not, my lord, it is not, his grievance is not the subject matter of my writ petition.
at all.
Yes. not
ಹಂಗಾಗಿ ಈಗ ಮೊದಲು ಮಾಡಿದ ಆರ್ಡರ್ ನಲ್ಲಿ ಇದು ಮುಗಿದು ಹೋಗ್ಬಿಡುತ್ತದೆ.
ಅಲ್ಲ ಅವ್ರದ್ದು
ಎರಡು WP ಇದೆ,
ಹೌದು,
ಹೌದಾ? ಆ
ಹೌದು.
ಎರಡನೇ WP ಅಲ್ಲಿ ಯಾರು ಪಿಟಿಷನರ್?
ಅವ್ರ ಪಿಟಿಷನ್.
ಇವ್ರ ಪಿಟಿಷನರ್.
ಹೌದು. ಅವ್ರದ್ದು ಏನಂತ ಹೇಳಿದ್ರೆ ಅವ್ರದ್ದು ಅಂಡರ್ 94
Recall that.
ರೆಗ್ಯುಲೇಷನ್ ಆಗಿ.
Recall that. Got confused. Recall that.
Sorry.
Yes, brother. That's all. Okay. Yes, tell.
The application number 94C was pending before the authority. By that time, on the complaint by.
But your client is convicted, but appeal is filed against that. Criminal appeal is pending.
94C, there is the exemption that if it is a house property, then 94C is not, under 94C, you can claim a regularization. My application was pending till 2023 year, for the year 2023. After that, my lords, in the year 2023, my application got accepted and now, my lords, I have got Hakkupatra for CH.
Subject property.
Subject. But on that, this also becomes instructive because my grievance was mandamus not to destroy the property.
Okay.
Now, my lords,
Barkalam.
that-
But you are convicted and appeal is still pending. Understood. Please be seated. Barkalam. This petition is by a person who having been tried for the offense of encroachment under the provisions of Karnataka Land Grabbing Act in 2011, has suffered an order of conviction and sentence. First off, counsel for the petitioner submits that against the said order, criminal appeal number so and so, ಅಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ರಲ್ಲ ಆಗಲೇ, is pending, entry ಮಾಡಿದ್ಯಾ? And that the sentence has been suspended, although conviction is not. First off. Next paragraph. Learned counsel for the petitioner submits that under the statutory policy, he has got the encroached land regularized in terms of, alida, adralli it note. Copy ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅವರು, Xerox copy.
Submission, my lordship.
Prior
to that issuing Hakkupatra, they had filed in a writ petition in 24754. My lordship have passed an order to
To
consider
consider that.
Hakkupatra issued based on this.
What you
order, my
have done? Regularized in terms of Hakkupatra dated 27
6/2023, the last.
2023 in accord with the order of this court in WP number
754
24754 of
22
2022. Disposed of on
14th December 2022.
14/12/2022. First stop. Next paragraph. In view of the above, it is submitted at the bar that this writ petition has become infructuous and we agree with the same. First stop. Ordered accordingly, WP is disposed of. Next.
Hearing for the petitioners, Your Honor.
Yes, brother.
Your Honor, this petition in brief is with regard to the appeal before the Debt Recovery Appellate Tribunal, which I had approached,
what-
challenging
ಇದೇನೋ ಫ್ರೆಶ್ ಏನೋ ಸ್ಟೆಪ್ಸ್ ಏನೇನೋ ಇದೆಯಲ್ಲ ಬ್ರದರ್?
with regard to R2.
ಯಾರವ್ರು R? Who is that R2?
Respondent number 2 is a company, my lords.
Now, how he is concerned with this petition, with this cause of action? You are a borrower,
I am neither a borrower nor the guarantor. That is my case, Your Honor.
is it?
I am in possession of the property.
How you entered into possession of the property?
I am the daughter's. My mother was the former wife of respondent number 3 in this case, Your Honor,
Your mother was former wife.
of the respondent number 3 in this case. That is, respondent number 3 and my mother were married. And through the marriage, I have got the property by way of gift, which I have, which my mother had got. My mother had gifted it to the petitioners here, to us.
When it was gifted?
The gift was given on 24/9/2009.
24/9/2009
2009.
is registered gift deed.
Yes, Your Honor.
When the loan was contracted?
The loan issue in 2010, what happens is that,
We are asking a question to you.
Yes, Your
It's a
Honor.
simple question.
I'll just come to it briefly.
It's all right. You can answer. You
Yes.
can take your own time to narrate whole of Iliad and Odyssey. We'll hear that. We are asking a question to you. When the loan was contracted?
I am not aware until I
All
received
right.
a
When the
13th
loan was
notice.
contracted?
2010 my lord.
Huh?
2010.
10.
Date ಹೇಳಿ.
Date.
And property is mortgaged.
Property that respondent number 3, he is the borrower, my lord.
We are asking
He
a
mortgaged the
question. Why can't
property.
you understand? Whether loan was secured by mortgage?
Yes, my lord.
That's the question. It was a mortgage debt.
Yes, my lord.
What is the amount?
The amount that 1 crore 41 lakhs
1 crore,
41.
41 lakh was the loan amount.
400
41 lakh 400. Loan amount.
loan amount.
Out of interest, how much it will
And
be?
everything put together 1 crore 41 lakhs, my lord.
Include. Yes.
I was made aware of this loan when I received a section 13 notice from the bank, to which I had challenged before, I had filed a writ petition before this honorable court, but this honorable court had directed me to approach the DRT. I approached the DRT, but it was dismissed, and therefore I have filed the appeal before the DRT. Your
On
Honor.
the ground?
On the ground that I am neither the borrower nor guarantor. This third respondent who is there in 2010 had deserted my mother and myself, and after which I have no contact with him. I am in possession of the property all this while. During that, in 2010, we came to know that this respondent has also made similar availed similar such loans in
Yes.
a different bank, which is my annexure D.
Who was the loanee?
Respondent number 3.
Or 3? Okay.
So in 2010, to protect my property, I have given a public notice cautioning the general public
When,
with regard to that.
when notice was given?
15/2/2010. It is in my annexure C.
15 to 2010.
10.
When the loan was contracted, Mr. Banks Counsel? ಮತ್ತ್ ಬೇಕಲ್ಲ ಅದು ಅದಿಲ್ದಂಗೆ ಹೆಂಗ್ ನಾವು ಮಾಡೋದು?
All that I am aware is that it is pursuant to the gift, Your Honors.
Huh?
All that I am aware is that the loan was allotted to the respondent number 3 after the gift to me.
After the gift.
Gift 2009, I was gifted the property.
Who gifted the property to you?
My mother,
Who was the, but loanee is not your mother.
no. My mother
But mother
received the-
gifted that.
My mother received the property from the respondent 3, who is the father.
Father gifted when? Father gifted the property to the wife,
To the wife,
to his wife,
to his wife, that is my mother.
your mother.
My mother gifted it to me in 2009. To me, that is 2 petitioners here and daughters. Pursuant to that, the loan was availed by the father without my knowledge, without my consent, by creating fake documents and whatnot.
Why bank will create fake documents?
That is my contention, because, Your Honors, I came to know about the activity about the father in by way of a caution notice issued by another bank.
Where is the gift deed?
My gift deed is at page 22, Annexure B, Your Honor.
This is 24/9/2009.
Yes, Your Honor, that is the gift deed.
Lakshman Reddy.
I'm sorry, Your Honor, I stand corrected. My mother gifted the property by way of her power as a GPA representing the father, not by way of gift deed. My mother represented her father, my father as GPA and gifted the property to me. So it is by GPA that my mother got it and I got it by way of gift. Please excuse me.
24/9/2009.
9 years. Now,
Read section 53 of the Transfer of Property Act. ಪಡಿ ನಾವೇ ಕೊಡ್ತೀವಿ. Any transfer of property to delay or defraud the creditor is void. 53 perhaps, 53 of the Transfer of Property Act.
fraudulent transfer, if I may read it. Fraudulent transfer, if I may read it.
Transfers. This is what my teacher is to tell.
Every transfer of immovable property made with intent to defeat or delay the creditors of the transferor shall be voidable at the option of any creditor so defeated or delayed.
Allahabad High Court has extended it to the contemplated fraud also. A section was drafted by Fitzgerald in the first law commission, of which Macaulay was the chairman. He drafted it in such a way that it would be attracted where the accomplished transaction is there. Allahabad High Court Justice Dhawan and Dixit, that bench, not this Dixit, that bench said, even contemplated fraudulent transfers would fit into precincts of section 52.
My only defense is that, Your Honors, at the time of the gift to me, I was neither aware that there is a loan or nor did the respondent number 3 contemplate that he has taken the
It is
loan.
not a transfer for consideration.
Yes,
You are a giftee. You are taking the rose along with the thorn which would grow after rose comes to your hand.
but my lords, at the time of the gift, there was no credit or there was no
Therefore,
loan
we are telling-
availed.
All these arguments are because you have not read the literature that developed under section 52. ಅದು ಓದ್ದಂಗ್ ಬಂದಿದ್ದಕ್ಕೆ ಇವೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್. ಇದರಲ್ಲಿ ವೇಸ್ಟ್ ಆಗ್ತದೆ ನಮ್ಮ ಟೈಮ್. ಯಾಕಂದ್ರೆ ನಿಮ್ಗೆ ನಾವು ಲೀಗಲ್ ನಾಲೆಡ್ಜ್ ಕೊಟ್ಟು ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ನಂತರ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀಬೇಕು. ಹೆಂಗ್ ಸಾಧ್ಯ ಇದೆ? ಹಿಂದಿನ ಕಾಲದಲ್ಲಿ ಹೆಂಗ ಆಗ್ತಿಲ್ಲ. ಎಲ್ಲ ಓದ್ಕೊಂಡು ಪರ್ಫೆಕ್ಟ್ ಇರ್ತಿದ್ರು ಅವ್ರು. ಎಲ್ಲ ಓದ್ಕೊಂಡು ಫುಲ್ ಪ್ರಿಪೇರ್ ಆಗಿ ಬರ್ತಿದ್ರು, ಬೇಗನೆ ಮುಗೀತಿದ್ವು ಕೇಸು. ನಿಮಗೆ ನಾವು ಲಾ ಕಲಿಸ್ಬೇಕು, ನಂತರ ನೀವು ನಮಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡೋದಲ್ಲ, ನಾವು ನಿಮ್ಮನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀಬೇಕು. ಎಲ್ಲ ಉಲ್ಟಾ ಆಗಿದೆ ಈಗ. 52 ಓದ್ಕೊಂಡ್ಬಂದ್ಬಿಟ್ಟಿದ್ರೆ ಎನಿ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬುಕ್ ಲೈಕ್ ಮಿತ್ರ ಆರ್ ಮುಲ್ಲಾ, they would have given full information to you as to how section 52 has grown. A graphical moment ಇದೆ ಅದಕ್ಕೆ, growth moment.
My lords, only with regard to the notice, it is just at the stage issue.
We are imposing cost.
My lords,
This is a fraud on the bank. Since you are invoking writ court jurisdiction, it's a fraud on writ court also.
my lords, my only submission is this one, the notice was served on the last date, but intentionally the respondents are, the remaining respondents except for the bank are avoiding it. That is
Your
why
father, he is none other than your father. Your father is the person who gave gift of the property. You are not an outsider.
that is the reason why, on the last date, this honorable court had made an observation asking me to file a application
Dismissed.
under
Dismissed. Section 52 to be discussed. Fraud to be discussed.
This property was sold for 1,41,400 and mother has purchased the property.
Again, mother herself has brought the property.
I have,
Now this
in
is,
order to secure the property, which is my ancestral property, I have put my money and saved it, Your Honors. My only
It
contention.
is nothing but a case of rank fraud.
yes, my lord, it is
See,
true.
your father, represented by your mother, gift the property to the children, daughters, and subsequently he mortgages that property and secures a huge loan. Then Since loan was not repaid, property is put to auction by virtue of decree and proceeds are taken. Auction purchaser is none other than the mother who executed the gift deed under the registered gift, the mortgage, the GPA. This can happen only in Alice in Wonderland. You are from Kannada medium or English medium?
English.
English medium. You should know. We may not know because we come from Kannada
My
medium.
lords, but after
This thing
2000.
can happen only in Alice in Wonderland. We are imposing a cost of rupees 5 lakh.
My lords,
Because
after
similar
2010,
matter-
I have
no, no.
got a divorce from the husband.
That makes no sense. Divorce is between the spouses. But once the spouses divorce takes place, that does not cut the umbilical cord with the father and mother.
Yes,
That
Your Honor.
makes no sense.
Only kindly see the last date's order, you know, that's all.
With
That
a
is all I'm
cost of
asking.
Rupees 1 lakh.
My lords, last date's order, you know,
Yes, nothing. We have come
26/5/2023.
Next, father. I'll ಇನ್ನೊಂದು sentence ಬರ್ಕೋ. Mother as the GPA holder of her husband had executed the registered gift deed in 2009, page 22. First stop. Father mortgages this property and raises the loan from the respondent bank. Semicolon. Loan now along with interest is quantified at 1,41,04,00,000 rupees. Full stop. Since the loan was outstanding, comma, mortgage property was put to auction and the highest bidder is none other than the wife of the loanee himself.
Mother of the petitioners.
They are the petitioners. One is petitioner,
Mother of the petitioners is.
mother of petitioners. Who is mother of petitioners? First stop. All this is a rank case of fraud and fits into the precincts of section 52 of the Transfer of Property Act 1882. First stop. In view of the above, the orders made by the DRT and the appellate tribunal cannot be faltered. First stop. Since constitutional jurisdiction is fraudulently invoked, comma, the petitioners are directed to pay a cost of rupees 1 lakh to the Legal Services Authority within 1 month, failing which it will attract a levy of rupees 1,000 per day, in addition to contempt of court.
My lords, last date's order, that's all I'm asking, Your Honor.
No,
My
we will
lords.
not. This is a fraud. Fraud by the family.
My
Whole
lords,
family is fraudulent.
after 2010, I have not at all been in contact
We
with
have
the father.
see,
Father has deserted the entire family, my
all
lords.
right, we
And
have,
I've also,
we have wrongly passed order. Your remedy is elsewhere. We may be wrong. Court has power to pass wrong orders also.
my lords, but at this
Next.
stage, only one submission is that
Next,
I have
next.
filed application for paper publication for notice to the respondents,
All right,
remaining
notice to
respondents.
third
That may be
respondent
considered,
is
Your Honor.
dispensed with. Since he is also a guilty fraud and everything appears to be very, very fraudulent. Okay. All right, dismissed with the cost of rupees 1 lakh. Yes. Legal says a copy of this judgment should be marked to the secretary, legal service Khalsa immediately. Yes.
I appeal for
Yes.
the
Yes. Arun,
petitioner in this matter.
held.
If the respondent did not contest the proceedings before the special court, the notice may be dispensed with at my risk, my lords.
All right. Counsel for the petitioner submits that the fifth respondent,
Eighth respondent,
eighth,
eighth.
Respondent who remains unserved, comma, notice in respect of him be dispensed with since he was not the contesting party in the special court. Okay.
Next
Wait.
Monday, this matter will be taken up, my lord. Some thing is there in this matter. Permanent injunction suit is transferred to the special court. Contrary to the Tumala judgment of the Supreme Court, special court says I have encroached the government land. 1955, when Maharaja was in rule, they had granted this granting aid was given to this school.
Argue ಮಾಡ್ಬಿಡಿ. You have said that now.
ಇವತ್ತು ಬೇಡ ನಾಳಿದ್ದು ಅಥವಾ ಯಾವತ್ತನ ಹಾಕೊಳ್ಳಿ
ಅಲ್ಲ
ನನಗೊಂದು
ಇಷ್ಟೇ ಕೇಸ್ ನಿಮ್ದು ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಅಲ್ಲ ಇಷ್ಟೇ ಕೇಸ್ ಬೇರೆ ಏನಿಲ್ಲ ಅದ್ರ ಕೊಡಿ
ಹೌದು.
ಮತ್ ಟೈಮ್ ಕೊಡಲ್ಲ ನಾವು.
Kindly see page 135. It is, I-
135.
yes. Annexure E1.
Government of Mysore.
ಹೌದು. ಇದರಲ್ಲಿ next page 136 your lordship may kindly see. Rounded off portion 529. Grantee need ಆಗಿರೋದು ಯಾವತ್ತಂತ. Ganapati High School Ebbur, there is the petitioner. It is the petitioner. Sanctions the payment of equipment grant of so and so. So the grantee need was admitted in 1955. ಅವತ್ತಿಂದ ಸ್ಕೂಲ್ ಇದೆ. And
Grant in aid. Where is the transfer of property?
transfer of property is by the panchayat.
Where is that?
Tax paid receipts are produced for 30 years. 30
No,
years.
that's not the question.
Yes.
Question is not that.
Yes.
How you got the title to this property?
Panchayat granted the land.
Where is that power
Yeah.
to grant the
My
land?
lord, that is why I requested day after tomorrow, your lordship may have it. I'll physically argue the matter. I'll come and it's
Any-
there in the records itself.
Reluctantly adjourn the matter to day after
Please, man.
for further hearing.
Please, man.
ಏನಿಲ್ಲ ಇಲ್ಲ ರಾಜ. Yes. Yes.
Lord's interim order has to be extended in that matter. I'm sorry, my lords.
It want to continue for 2 days.
Please, man.
Yes. 134. Second time. ಏನಂತ ಬಂದು notice? Since neither insufficient progress. ಯಾವುದಕ್ಕೆ? Issue police notice to respondent numbers R1, R3 and R4 immediately. Yes. Next. First time. For first time. But ಯಾಕೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವಾ ಆದಾಗ? ಎಂಟ್ರಿ ಮಾಡಲ್ ಕೊಟ್ಟಿದ್ರಾ? ಎಂಟ್ರಿ ಮಾಡಲ್. This writ petition was filed on 18/12/2019, laying a challenge to the special court's order dated what is date, see, but yeah.
Challenging the proceedings, my lordship.
Huh?
They're challenging it to quash the proceedings.
Proceedings, lower LG, special courts proceedings in LGC number 372/2019. First, order sheet ಕೊಡಿ.
Annexure E.
A coordinate bench of this court, wide order dated 3/3/2020, had issued notice to the respondents First, till date, no steps are taken. And we are in January 2024-25. First, in view of the above, writ petition is dismissed for non-prosecution. Sorry. ಯಾವಾಗ ಫೈಲ್ ಆಗಿತ್ತು ಸೇಮ ನೋಡಮ್ಮ ಅದೊಂದು ಬೇರೆ ಆಗುತ್ತೆ LGP ಕೇಸ್ ನಂಬರ್ ಒಂದೇ ಬೇರೆ ಆಗ್ತದೆ ಚೇಂಜ್ ಮಾಡಿಸ್ತಾರೆ ಡಿಸ್ಮಿಸ್ಡ್ ಹಾಕಿ ಅಲ್ಲಿ ಎರಡರಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ಈಸ್ ಅಬ್ಸೆಂಟ್ ಅಂತ ಬರ್ಕೋಬೇಕು ಫಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ ಓಕೆ ನೆಕ್ಸ್ಟ್ ಬಡಿ 1 week granted for taking fresh steps, failing which petition stands rejected peremptorily. ಅಲ್ಲೇ ಗವರ್ಮೆಂಟ್ ಎಡ್ಯುಕೇಟ್ ನೋಟಿಸ್ ಯಾರೇ ಕೊಟ್ಕೋಬೇಕು ಆಗಿದೆ ಏನದು ಇಲ್ಲ. ಆಲ್ ರೈಟ್. ನೆಕ್ಸ್ಟ್ ಅವ್ರಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು ಹಿಂಗೆ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ. ಓಕೆ.
For the petitioner, your lordship, in this matter, already I am paid the 5,000 rupees cost on,
When you paid? You have paid the cost now?
yes, your lordship, 15/3/2024 itself, your lordship.
What
but
is
acknowledgement
this
is
matter
not.
to that? Cost ಕೊಟ್ಟಿದ್ದಾರೆ. Counsel for the petitioner submits the cost ordered by the coordinate bench on 15/3/2024 has been paid.
That day itself, your lordship, 15/3.
Argue.
Your lordship, kindly have it on tomorrow, your lordship. My
Call
son-
tomorrow
Yes.
on request. Yes. Ramesh was not well, primarily live. NJ Ramesh was not well. Is he all right now? All right. Call this matter next week to enable counsel for the petitioner to take steps and address office objections. ಮಾಡಿದಾರ? ಓವರ್ರೂಲ್ ಮಾಡ್ಬೋದಾ? ಅಲ್ಲಿ ನೋಡಿ ಫಸ್ಟ್ ಲೈನ್ ಆಫೀಸ್ objections overruled. Steps to be taken within 1 week. Entry ಮಾಡಿದೆಯಾ? ಇಲ್ಲ. Failing which petition stands rejected peremptorily. Okay.
For petitioners, my lords.
Yes.
Copy has been served, my lord, today
Ah.
to AG office.
Office objection addressed. Start. Yes, brother.
Kindly have it next week, my lords.
ಎಂತ ಸ್ಮಾಲ್ ಮ್ಯಾಟರ್ಸ್ ಇದು. ಒಂದು ಸ್ವಲ್ಪ ಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು ನಾವು ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
No entry
ಆರ್ಡರ್
order,
ಕೊಡ್ತಾ
my lords.
ಇದ್ದೀವಿ.
No
ಅಲ್ಲ
entry.
ಫೈನಲ್ ಆರ್ಡರ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
I am not counsel on record, my lords.
ಇದೊಂದು ಚಲೋ ರಾಮ್ ಬಾಣ ಇದು.
Next week, my lords. He is unwell.
Call next week at the request of counsel for the petitioner. ಚಿಕ್ಕ ಮ್ಯಾಟರ್ಸ್. ಸ್ವಲ್ಪ ಓದ್ಕೊಂಬಂದ್ರು ಸಹಿತ ನಾವು ಅವ್ರಿಗೆ ಒಂದು ಮುಷ್ಟಿ ಮಾರ್ಕ್ಸ್ ಜಾಸ್ತಿ ಹಾಕ್ತಾ ಇದ್ದೀವಿ.
I know.
ಹಂಗಂದ್ರೆ
but
ಏನು ಅಂತ ಕೇಳ್ಬೇಡಿ.
In depth, I have not gone through.
Anyway,
ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡು ನೋಡಿದ್ರೆ
ಆಯ್ತು, ನೋಡ್ಕೊಂಡು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿ.
please, please.
ಅಪರ್ಚುನಿಟಿ ಅಲ್ವಾ? ಎಸ್ ಆದಿತ್ಯ.
This matter pertains to. Lords, I will be permitted to take hand summons as well
And some
through my officers, my lord,
That-
and I will also pay the process fee, etc.
Issue fresh notice. First off, in addition, comma, second petitioner is permitted to take hand summons to the respondent assessee. Correct?
My lords,
Assessee.
deeply realized.
Lord, appear for the
Vilma?
petitioner, my lord.
Yes.
Lord, we have taken the steps, my lord. And, the
Steps ತೊಗೊಂಡ್ರಾ?
process fee, we have paid them.
When you have paid?
After this 8/11/2023 itself, we have paid.
Paid it. ADLR,
Please,
sorry, AG is, HCGP is requested to accept notice for fourth respondent ADLR. Start. R1 error.
otherwise is a de facto complaint, my lord.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗಿತ್ತಾ? ಏನಂತ ಬಂದ ರಿಪೋರ್ಟ್? ಲೆಫ್ಟ್.
And he is also not attending over there also, my lord.
There also is not.
He is not
Will
attending.
issue police notice to him.
Please.
Registry to issue police notice to the first respondent who was the complainant before the special court.
Okay, and also, my lord, I am asking for the interim order, my lord. This matter pertains to the land grabbing that has been allegation made against Rajya Okkaligar Sangha, my lord.
and
ಒಕ್ಕಲಿಗರ ಸಂಘ
ಒಕ್ಕಲಿಗರ ಸಂಘ, my lord.
ಅವ್ರು
And
ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಅವ್ರು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. This is a land where if my lords could peruse, my lord,
ನೀವ್ ಹೆಂಗೆ ಲ್ಯಾಂಡ್ಗೆ
1909, my lord, it was granted, my lord, if my lords could peruse annexure E page 110 of the petition, my lord.
110.
110, my lord. His Highness Maharaja of Mysore has granted the land, my lord. This is, if my, that relevant portion is 111, my lord, serial number 62. If my lords could peruse the sanction to
The fee
free
grant.
grant subject to the certain proviso to the Vakligara Sangha of the pieces of land to the east of so and so 12 acres, 16 guntas for the purpose of establishing a printing press, erecting a hostel
for students.
and for students and other buildings, my lord. Pursuant to this, my lord, the 112, they make an order, my lord.
ಇದನ್ನ
This-
ಕನ್ಸಿಡರ್ ಮಾಡ್ಯಾರ?
This has not been considered.
Not considered it.
Not considered at all by that. And they have taken the cognizance, my lord, still the matter is pending before the LGC, my lord. And if my lords could peruse,
Learned counsel for the petitioners draws attention of the court to the order of government of His Highness the Maharaja of Mysore dated 31/3/1909, whereby the subject land has been granted for the purpose inter-alia of printing press, establishing printing press and erecting a hostel for students. First stop. A copy of said proceeding is at Annexure E. First, next part, counsel for the petitioners submits that this aspect having not been adverted to by the special court functioning under the 2011 Act, comma, there is error apparent on the face of record warranting grant of reprieve. First, we agree with this. First, in view of the above, all further proceedings pursuant to impugned order dated 9/8/2019 stand interdicted.
much obliged.
ಅಷ್ಟೇ ಇರ್ತದಪ್ಪ ಇಂಥ ಕೇಸ್ನಲ್ಲಿ ತೋರ್ಸೋದು. ಏನಿರ್ತದೆ ಲ್ಯಾಂಡ್ ಗ್ರಾಬಿಂಗ್ ನಲ್ಲಿ? ಟೈಟಲ್, ಹೌ ವಿ ಹ್ಯಾವ್ ಡಿರೈವ್ ದ ಟೈಟಲ್, ಮುಗ್ದೇ ಹೋಗ್ಬೋದು. ಎಸ್, ಅದನ್ನು ಮಾಡಲ್ಲ. ಎಸ್ ಎಸ್ ಆದಿತ್ಯ,
There is
ಅಸೆಸ್ಮೆಂಟ್ ಆರ್ಡರ್. ಅಸೆಸ್ಮೆಂಟ್ ಆರ್ಡರ್ ಫೈಲ್ ಮಾಡಬೇಕಲ್ಲ?
there is no such assessment order. There is a typographical
ಅಸೆಸ್ಮೆಂಟ್ ಆರ್ಡರ್.
and subject to what my learned friend said.
Then why are you here?
Words, the date, if your lordship see, in the first appellate order, the wrong date is at page number 29, my lords.
29.
Page 29, the date 8/3/2013 appears for the first time.
31/5/2018.
Howdu, if your lordships take the second paragraph.
Second paragraph. You are right,
8/3/2013
8/3/2013.
appears for the first time.
Ah.
This same error committed by my first appellate authority is carried over on page 14 in the order of the tribunal, my lords. 8/3/2013. The actual date, my lords, is 8/10/2013.
It has to be 8/10/2013.
Which is produced, which is already on record. There is no separate order,
But then come to para 3.
my lords.
If your contention is accepted, how can there be 11/10/2013?
11/10/2013, my lords, is the notification, my lord.
Hmm?
11/10/2013 is correct.
Reassessment order.
Yes, ma'am.
Para 3, page 29.
Page 3. My lords, the appellant has filed these appeals as against the date of service of reassessment order on 11/10/2013, which is within the stipulated time of 30 days. So therefore, my lords, it 8-10 ಇಂದ ಅವ್ರು 11-10 ಹಾಕಿದ್ದಾರೆ, which is within 30 days.
What do you say, brother?
I'll verify, but I didn't.
Doesn't
Yeah,
appear to
very
be any
well.
conflict.
Within that time ಇದೆ. The order ಏನೇ ಇದೆ. Workali.
Because otherwise, if it had been 8-3, my lords, then it will not be within the period of 30 days.
ಅವಾಗ exceed ಆಗ್ಬಿಟ್ಟು.
Exceed. 6 months, I thought.
8-10. 8-10 seems to be there.
The order,
Eight-
it is
8-10.
there, it is there before your lordship.
It's there in the order itself.
Yes,
Para 3.
the order says 8-10.
If your lordships take page
If it
44,
is 8-10.
page 44, it is 8-10. And
The appellate order ನಿದು.
appellate order is at page 29.
Then 8-10 order is
The reassessment order, 39-2 of the VAT Act. From reassessment order, first appellate order, tribunal order, the entire sequence is there.
ಏನು objection ಏನಿದೆ ಆಫೀಸ್ ಈಗ? ಏನಿಲ್ಲ.
ಏನಿಲ್ಲ.
For issue notice to respond number,
ಬಂದಿದ್ದಾರೆ.
non-filing of copy of reassessment order dated 8/3/2013 will not, question
Will
will not.
May not survive.
The office note as to non-filing of assessment order dated 8/3/2013 does not, is
It
is
is,
liquidated. Liquidated. Yes,
my lords,
ready in
is-
the matter?
Next week, minutes.
Call this matter week after next
Obliged.
at the request of counsel for the assessing. Yes,
Hearing for the petitioner, my lords, I'll take the necessary steps. Matter may be
non-compliance
lifted.
office objections,
Please,
second time.
I will do the needful. The matter may be taken up after 2 weeks, my lords.
2 weeks.
Please.
ಏನದು steps ಏನು office objection ಏನಿದೆ? So fine. Assistant Commissioner of Commercial Taxes already stated correctly.
what's the office?
Concept of petition papers to be attested by the council. Office objections to be addressed within 10 days. Call after
Yes,
2
please.
weeks.
Grateful.
Deeply.
Yes.
Lordship seeking a week's time, Your Lordship.
Not ready.
We'll comply with our objections in about a week's time.
There is no IA2 for additional documents filed by advocate for respondent one, IA for vacating it. What are the objections? Huh? Translation dispensed it. Dispensed it. Yeah, no, that is over.
Your Lordship, there's also an unavailability because we're led by Senior Counsel, Mr. G.L. Vishwanath. He may be.
Call
getting
week
late,
up to next at the request of counsel appearing for respondent, private respondent. Yes,
Obliged.
entry order ಇದೆಯಾ?
No, just
Entry, absolutely.
Yes.
All right. Entry order to continue till next date of hearing. All right.
Sixteen,
Kumar.
we have served the hand summons on fourth respondent. And an acknowledgement is also filed.
You have served.
Yes, ma'am.
Fourth respondent is registered Karnataka land grabbing court, my lord.
Yeah,
He had appeared before this court on 13th, my lord.
why
Twelve-
he, in the latest judgment,
if
they
it-
cannot be
the-
made party
This
at
court
all.
directed
But
to.
this court directed by an order of this court.
To
on
impede
12th
him.
Yes. And then he was made with party and hand summons was served on the same day. Next day he appeared and produced the document, then order 13th October 2023 was passed by this honorable court. My lord, this is a
But the-
playground, my lord.
Order of this court is to come to the conclusion. Kindly see the order minute.
Yes,
In the light of the order passed
The
by
other
this
court.
court.
Other bench. Yes,
That's a question that's to be answered.
Sir, we'll take up the matter on merits only. Yes, good. Are you ready in the matter?
Yes.
Yeah, you accept notice for registrar, na?
I don't have a copy of the writ petition, my lordship.
Yenamma?
Writ petition copy, it's not.
But ilva?
ಇಲ್ಲ.
Or one copy of the petition, call tomorrow.
We'll also have it on day after tomorrow.
Day after. Okay. Entry order to continue till then, till next date of hearing, yes. Or you copy ಕೊಟ್ಬಿಡಿ ಶಿವಕುಮಾರ್. Next.
My lordship, to comply the office objection, 2 weeks time, my lordship.
2 weeks for compliance. Yes.
Appear for the appellant in this matter. My lord, the office has raised the objection regarding translation of Kannada.
Dispensed it.
My lord, there is a delay of 524 days in filing this appeal, my lord.
The order, what
Right.
is that order?
My lord, the order pertains to the value of the tax of pre-GST and post-GST period, my lord. This is regarding the works contract matters where the contractors had entered into an agreement with state government and various departments post pre-GST, my lord, where the Karnataka value added tax was there, my lord. Subsequently, introduction of GST 2017, the value of the tax, that is rate, was changed to 18%, my lord. Aggrieved by that, the respondent number 1 approached this honorable court, my lord. This honorable court has passed a common judgment, my lord, that this is the list of cases.
ಇಂಥದೇ ಇದೆಯಾ?
Intade, arising out of the common order. It's a common judgment.
Connected matter has gone to the 20th.
20th.
20th. This
Call this matter on 20th.
please.
I may be permitted to take notice for 2, 4, 5, 6, 7, my lords.
Learned AG Aditya Vikram Bhatt accepts notice for respondent numbers.
2, 5, 6, and 7.
Sense. ಬೇರೆ ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು notice?
4 Janpat.
Emergent notice to.
ಇಲ್ಲ 4 commercial taxes. 4 commercial taxes.
CMC.
ಅಲ್ಲ ನೋಡಿ ರೀನಂಬರ್ ಆಗಿದೆ.
Shanti, 3 and 4 Shanti.
3 and 4 Shanti.
1 I'll.
Emergent notice to R1 and R8. R8. Steps to be taken before the sunset of the day. Entry ಮಾಡಿದ್ಯಾ?
Entry materials.
Alaswamy.
Lordship, 1 week time may be granted to comply office objection.
10 days for compliance.
Much of it.
Fourth time. Fourth time it is coming.
My Lordship, you have not got instruction from our client, my Lordship.
Again, compliance again instruction ಬೇಕು ಹೇಳಿ.
The documents are.
ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್? ತೋರಿಸಿ.
Second set file ಮಾಡ್ಬೇಕಿದೆ.
ಅಲ್ಲ ಫುಡ್ ಫೀ ಕೊಡಬೇಕು, ಇದು ಮಾಡಬೇಕು. ವೈ ಹಾಲ್ಸಮಿ ಜನರಲಿ ಹಿ ಡಸ್ ನಾಟ್ ಡೂ ದಟ್ ವೇ. ಒಂದು ಒಳ್ಳೆ ಬುಕ್ ಕೊಟ್ಟುಬಿಡಿ. ಒಳ್ಳೆ ಒಂದು ಬುಕ್ ಕೊಟ್ಟುಬಿಡಿ ಲೈಬ್ರರಿಗೆ.
No, my Lordship, 1 week time may be granted.
ಕೊಡೋಣ. 1 week ಅಲ್ಲ, 10 days ಕೊಡೋಣ, ಬಟ್ ಒಂದು ಬುಕ್ ಕೊಡಿ. Petitioner to comply with the office objections within 10 days. Further, he has to present one book, Precedent in English Law by Rupert Cross, to the Advocates Association Library. In the meanwhile, okay. Next. Entry ಮಾಡಿದೆ ನಲ್ಲಿ?
No, ma'am.
Okay. All right. Notice ಆಗಿಲ್ಲ. Peremptory order. Peremptory order. ಎಲ್ಲ peremptory order court goes. Yes.
For the petitioner, my lords. My lords, a 2 weeks time may be granted, my lord. There is office objection which will comply in the meanwhile.
4 times it was granted. No, we will not grant time.
First time it is before this court, my lords. It was first time it is before this honorable court, my lords.
Yes, sir. Even not shit ಕೊಡಿ. 4th time. 25,000 rupees cost ಕೊಡಿ. Otherwise, we are dismissing the petition.
My lord, one week time may be granted. my lord.
ಕೊಡೋಣ, 2 weeks ಕೊಡ್ತೇವೆ.
Will comply,
ಅಲ್ಲೇ 2 weeks granted for ಅಲ್ಲಿ ಬರ್ಕೊಳ್ರಿ. 3 opportunities were granted for compliance. And today, for the fourth time, matter is posted. First, counsel for the petitioner again seeks time for compliance. First, very reluctantly and conditionally, we are acceding to the prayer and grant 2 weeks for compliance, subject to the condition that the petitioners shall pay rupees 10,000 to
My
the
lord, my lord,
Khalsa
my lords, my lords,
within the said period,
my lords,
failing which petition stands rejected.
my lords, my lord, not the 10,000, my lords, I can give a book to the library, my lord.
ಅವ್ರ ಲೈಬ್ರರಿ ಕಲ್ಸೋದಕ್ಕೆ ಹೋಗ್ಬಿಡಿ. ಬುಕ್ ಯಾರು ಓದೋರು ಇಲ್ಲ ಅಲ್ಲ ನಮ್ಗೆ ಈಗ. Nobody is reading the
At
books.
least 5,000, my lords, because
5,000 to Khalsa.
much of it.
And failing which petition stands rejected. Okay.
My lord, humble submission, my lord, there are office objections to be complied, my lord. Second set has to be given and annexes has to be added, my lord. Short accommodation be granted, will comply it of, my lord.
Yes, sir, ಬಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಕೊಡಿ. ಆಗಿದೆ.
It is recall on the IA, my lord. Will comply
Pay
second.
10,000 rupees to the
Please, my lord.
Khalsa.
Weeks time you granted.
We 2 weeks ಕೊಡ್ತೀವಿ ಈಗ. 10,000 rupees to Khalsa. You cannot
Yes.
waste the time of the court that way.
Lesser, my lord, lesser.
Less.
5,000 was.
All right. The petition was dismissed by peremptory order dated 25/11/2022 by the registrar. So and so. First, an application supported by the affidavit is moved, seeking recall of the order and restoration of the matter. First, restoration of the matter to the board. First, this case is of the year 2020, and we are in 2025 now. First, next one, in view of the above, the subject application having application in IA number 1 of order on IA number 1 of 22. Subject application having been favored, the peremptory order is recalled, and as a consequence, writ petition is restored to the board, subject to the condition that the petitioner shall pay. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? Petitioners ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಒಬ್ರಿ, my lord.
Petitioner shall pay rupees 5,000 to the Khalsa within 10 days, failing which petition shall stand rejected, and any prayer for restoration may not be considered favorably.
Second objection is to related to translation, my lord.
Dispensed with. Okay. Next.
There's a delay in this matter.
Yeah, for the respondent in this matter, my lords.
Yeah, condonation ಮಾಡೋಣ.
Please, my lords.
Appeal, revision petition is preferred after broking a delay of 284 days. First, application in IA number 1 of 2023, supported by an affidavit, accompanies the petition seeking condonation of the same. First, the explanation being plausible, comma, application is allowed and delay is condoned. Next.
Respondent.
Ah.
Delay in this matter, my lords.
Delay condone ಮಾಡೋಣ.
Very well.
Same order.
I'm for the respondent.
ಇಲ್ಲಿ ನೋಡಪ್ಪ, ಮೊದಲನೇದ್ರಲ್ಲಿ 284, ಎರಡನೇದ್ರಲ್ಲಿ 246, ಮೂರನೇದ್ರಲ್ಲಿ 117. ಅಯ್ಯ ಅಲ್ವ, ಆರ್ಡರ್ ಅನ್ನು ಅಯ್ಯ ಅಂತ ಮಾಡ್ಬಿಟ್ಟು. Yes. 25. Delay condone ಮಾಡೋಣ.
For the respondent, no, my lord.
ಯಾಕೆ?
My lord, there's administrative reason, my lord. So
ಗೌರ್ಮೆಂಟ್ ಅದು.
refund issue, my lord. So
ಇರ್ಲಿ.
prejudice ಆಗತ್ತೆ, my lord.
ಇದಕ್ಕಿಂತ older matters are still
My lord,
languishing in the court.
refund
But
issue prejudice ಆಗತ್ತೆ, my lord.
Same order, 535, delay condoned.
Deeply appreciated.
Okay. ತನ್ಮಯ್ delay condoned ಮಾಡೋಣ ಅಂತ.
ಈ ಥಿಂಗ್ ಮೈ ಲಾರ್ಡ್ಸ್ 1 year ಇಲ್ಲೇ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ದಾರೆ. 22 ಇಂದ 23 ವರ್ಗೂ ಮಾಡಿಲ್ಲ, ಮಧ್ಯದಲ್ಲಿ 1 ವರ್ಷ. I just
ಸಾಲೆ. Same order. ಆ ಡೇಸ್ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು. Yes.
The respondent statement.
Allowed dispensation as sought for his grant.
This matter is really a habeas corpus matter. Initially, it was filed for certiorari. It's to be reclassified as a habeas corpus because it is a case where a preventive detention order is being questioned.
Please. Registry to reclassify this matter as a habeas corpus in view of argued change of circumstance.
But,
As submitted by learned senior advocate Mr. Ashok Karnali, appearing for petitioner.
on merits, my lord.
My lords, sir, roster bench is
Okay,
at,
post this matter before the roster.
roster bench, my lords.
Okay.
They are-
My lords, as it's,
For statistical purpose, petition is, shall be treated, notionally treated as having been disposed of. Okay, post before, renumber the petition
submission,
and
my lords,
post it before roster bench.
it would be better, it would be, if it had been withdrawn, my lords, as the order of approval has been passed by the government. And the
Approval has been
matter-
granted now.
Please, my lords, approval has been
Permission
granted and it's been
authorized
placed before the
Because
advisory
I got
board.
liberty court.
Petition will not get affected. Now, under law, my lord, it has to be confirmed by the state government within about 12 days. They may have confirmed it, but the
It's
confirmation
approved,
is
my
of
lord.
the
It's approved and
detention
closed
order.
before
I
the
did not
advisory
check.
board.
All right, ಅಲ್ಲೇ contention ಮಾಡಿ.
Please.
But lordship could give an early date,
ಆಗ್ಬೇಕು. Post this matter
tomorrow or day after.
before the roster bench at the earliest.
Habeas
Day
corpus.
after, day after. Okay. Next. Yes.
My lord, the learned single,
Delay condone ಮಾಡೋಣ, 23 days ಇದೆ. ನೋಡಪ್ಪ, delay condone ಮಾಡ. ಹಾ. ಹೇಳಿ.
my lord, the learned single judge set aside the order of assessment, my lord, on the ground that the preliminary notice under section 148 as well as the order of assessment was done on the dead person.
Yes.
Now, my lord, my contention is, my lord, before the issuance of notice under 148 for reassessment, my lord, after the amendment, the procedure was, my lord, a notice under section 148A, my lord, giving him the opportunity to respond why a notice should not be issued under 148 will be given. And my lord, subsequently, an order under section 148D will be passed considering the objections filed.
I decided similar
ಇಲ್ಲ
matter.
ಇದರಲ್ಲಿ ಏನಂದ್ರೆ
ಹಾ.
whole issue comes down to, my lord, undisputed fact is notice under section 148 was issued on a dead person. My lord, my lord, submission was made before the learned single judge seeking liberty to proceed against the legal representative. And the learned single judge, my lord, looking at the date, said it is barred by time and I cannot give you that. My lord, anyway, it is barred by time and any issuance of notice cannot be done now at present. Our submission before this honorable court is, my lord, original notice when it was issued,
He was alive.
no, he was not alive. My lord,
Now, how you will know whether assessee is dead or
that is,
not?
only the after, my lord, what happens, I'll just submit the sequence of events. My lord, the dates are important, my lord. 148 AB notice seeking
Just for the benefit of, made a list of dates, same dates.
ಇದೆಯಾ?
only 4 dates are there.
ಅಲ್ಲ, how government will know? How Caesar will know citizen is dead?
That I think, one, the death was registered. Secondly, my lord, this question has come up before other honorable courts also, where they said that the requirement is not upon the SSC or rather the LRs of the SSC to intimate about the death.
Correct.
For,
My lord, that
in
is-
my case, I did intimate about the death immediately after the first notice was sent to me.
When death occurred?
My lord, let's see, at the first thing,
My
14.
lord, expired on 14/10/2022. My lord, there are only 4
Period,
dates.
one ನಿಮಿಷ. They also come with some preparation, huh? ಲಿಮಿಟೇಷನ್ ಯಾವಾಗ ಎಕ್ಸ್ಪೈರ್ ಆಗ್ತಿತ್ತು?
31/3/2023.
ನೀವು ನೋಟಿಸ್ ಯಾವಾಗ ಕಳಿಸಿದ್ರಿ?
My lord, the first notice before the issuance of 148, that is notice under section 148 capital A B, issued on 31/1/2023. Subsequently, another notice.
1 ನಿಮಿಷ. 31/10.
31/1/2023.
This is section 148 AB.
AB. As there was no response, my lord, another notice was issued on 15/2/23.
(15/2/23).
23. Another opportunity. ಆಮೇಲೆ ಏನಾಯ್ತಂದ್ರೆ on 15, sorry.
But he was already dead.
He was already dead.
So notice was, one second. Now, sorry. Notice was sent from your office post death.
Post death.
One niche. Okay. You came to know that he has left LRs when? When you came to know?
Overleap.
Page number, that is, my lord.
ನೀವು ಹೇಳಿ.
28/11/2020.
Because you sent the reply.
Yes, I sent.
28/11/2023.
In the list of dates I mentioned, the second page. Because the initial notices
No,
were
no,
only on
there
the
are two-
portal. They were not physical, when my learned friend says sent to the deceased, they were put up on the portal of the deceased. Only he would have access to it had he been alive. So subsequently, when
But how you came to know?
the subsequent notices physically were sent to me by post to the LR of the deceased. Then I immediately responded on 3 separate occasions saying, I'm sorry, but this person has passed away. This is the death certificate. Please do not proceed in the matter against the deceased. Despite that, they have issued it against the deceased. That time and again, this honorable.
No, by the time you sent,
Yes, ma'am.
whether limitation was still there or not.
It had expired.
It had
Lapsed.
It had expired.
Yes, yes.
So that makes no difference now. In such matters, how the learned other courts have treated the matter in the country?
Yes, in fact, this honorable court also has taken that. I'll place it. I'll take my notes to that, but in short, what they've said is that even if the initiation of proceedings has to be done against a living SSC, if it is initiated against a deceased SSC, then they can proceed against the LRs if the limitation was, had the person been alive at that time, that the proceedings could be continued.
But how government will know?
Yes,
Whether citizen is dead or not, registration, the registration of Births and Deaths Act 1968-69. That act is for statistical purpose. It is not treated as a notice to the world at large like Registration Act. 1908.
Yes.
1908 Act. Registration of a conveyance which is compulsorily registrable if registered is notice to the world at large.
Yes.
Because there is such a section. ಇದರಲ್ಲಿ ಅಂತ ಸೆಕ್ಷನ್ ಇಲ್ಲ.
Under the income tax act.
ಇಲ್ಲ, before going to the issue, my lord, 159 section,
ಪಡಿ.
159(3).
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಕ್ಟ್ 159(3). ನೀವು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಅದು ಬಹಳ ಡಿಫಿಕಲ್ಟ್ ನಮ್ಗೆ ಹುಡುಕೋದು. ಅದಕ್ಕೆ ನೀವು ಬರುವಾಗ 2 ಕಾಪಿ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ತೊಗೊಂಬಂದು ಕೊಟ್ಬಿಡ್ಬೇಕು. ದಟ್ ಸೇವ್ಸ್ ಲಾಟ್ ಆಫ್ ಟೈಮ್. ನಿಮ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಅಂದ್ರೆ ಇದು ಕಾಸ್ಮಿಕ್ ಜರ್ನಿ ಮಾಡೋದೇ ನಾವು ಸಾಧ್ಯನೇ ಇಲ್ಲ ಹುಡ್ಕೊಳ್ಳಿಕ್ಕೆ. ಇಟ್ಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ಟು ಲೊಕೇಟ್.
Lord, that is in page
As cumbersome as tax
1095.
law itself. Huh?
1095 page,
1095.
section 159. 1.1095.
Legal representatives.
My lord, 3.
1 second. Where a
Two
person
makers.
dies,
2.
his legal representative shall be liable to pay any sum which the deceased would have been liable to pay if he had not died, in the like manner and to the same extent as the deceased. That means if he takes the estate of the deceased.
Then 2, for the purpose of making an assessment, including an assessment, reassessment or recomputation under section 147 of the income of the deceased, and for the purpose of levying any sum in the hands of the legal representative
in accordance with the provisions of subsection 1, any proceeding taken against the deceased before his death shall be deemed to have
Taken
taken
against
against the
LR.
legal representative. That will not apply because he was already, my lord, dead here.
Any proceeding, one second, any proceeding taken against the deceased before his death,
Before
when he
his
was
death.
alive. But
Alive.
that question will not arise because he had
Please,
already
please,
deceased.
please. Any proceeding which could have been taken against the deceased if he had survived may be taken against the legal representative.
But limitation ಬಗ್ಗೆ ಎಲ್ಲಿ ಏನಿಲ್ಲ.
Question ಬಗ್ಗೆ ಬರುತ್ತೆ. I'll come back, my lord.
ಎಲ್ಲಿದೆ?
And my lord, but see, all the provisions of this act shall apply accordingly. Then 3, the legal representative of the deceased shall, for the purpose of this act, be deemed to be an SSC. Now, my lord, definition section, my lord, 2(7), my lord defines who is a SSC. Section,
Legal representatives also.
yes. SSC means,
All right, we have understood.
SSC means
Why are you reading it again? We agree with you. Still you want to read? Yes. How that's going to alter the position?
my lord, my humble submission is the day on which the original notice was sent
He was
under
alive.
section 148(a)(b), my lord,
He was not alive.
he was not alive, but the legal representatives will be deemed to be an assistant.
Provided you send notice to the legal representative. Otherwise, it will, very provision will be defeated. We understand there is some difficulty in that.
Because there were three notices sent, orders passed
Makes no
before
sense.
issuance.
You might have sent 100 notices. Whether they will fit into the precincts of law is the question.
But this is a limited issue, my lord.
But the lawmaker should have adverted to that and said something. How courts have interpreted this? How various other courts? There is one English judgment in Cox criminal court cases, CCC. Those reports came during the 1926 to 1937. 11 years ಅಷ್ಟೇ ಏನೋ ಬಂತದ್ದು. ಅದರಲ್ಲಿ ಇಂಥದೇ ಒಂದು ಕೇಸು ರಿಪೋರ್ಟ್ ಆಗಿದೆ, ಟ್ಯಾಕ್ಸ್ ಸಂಬಂಧಪಡೋದು. ಅಲ್ಲಿ assessee had died. He died before the expiry of the limitation period. But they sent notice to the deceased. It returned. Thereafter, they came to know that as death of assessee. They issued notice after the expiry of the limitation. English court said, in such case, limitation would stand elongated because there is no law which compels the crown to know the death of citizens on that ground. ಬೇರೆ courts ಹೆಂಗ್ hold ಮಾಡಿದ್ದಾರೆ? How this issue is treated?
I'll just take one learned single judge of this honorable court, and another case has in fact answered this very question posed by my.
How it is, how it reads.
Just
Read. ಇವರು ಅವನಿಗೆ ಕಳಿಸಿದ್ರು, ಅವನು ಮತ್ತೆ ರಿಪ್ಲೈ ಅಂತೇಳಿ ಅವನು ತಗೋಗ್ಬಿಡ್ತಾನೆ. ಅದಾದ್ಮೇಲೆ ಇವರು ಕಳಿಸಿದ್ರು, ಅಷ್ಟೊತ್ತಿಗೆ ಲಿಮಿಟೇಷನ್ ಅಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಏನು? How learned single judge has worked out?
In this case, I'll just briefly tell the facts. Even in that case, the SSC had passed away before the impugned 148 notice came to be issued. The notice was issued in the name of the deceased person. The question which arose before this honorable court was, after becoming aware of the death of the deceased, the limitation to issue a notice to the LRs had lapsed. So the question was, could the notice issued to the LR after lapse of limitation, would it still be valid? This honorable court has, looking at the provisions, has held that the true test is the initiation. Initiation against a deceased SSC is void ab initio and invalid. So there was no notice at all issued in time. So if the limitation had already lapsed, now issuing it to the LR would not cure the original defect. And that order has not been appealed.
That's all right.
Yes, and it is followed 2-3 decisions of the Delhi High Court, Gujarat High Court, and
Are they division benches or single?
all
benches?
division bench.
Division benches.
Yes.
But we don't agree with that view.
I'll place that.
Otherwise, see, death happens in every house, which Lord Buddha told Isa Gautami. In every house, death happens. In a country where 140 crore people live, how government, central government will know, that too in a federal structure, which citizen is dead when? Therefore, Denning says, where the statutory provision does not provide for a remedy, the judges should read such statutory provisions as if the lawmaker would have read had it been brought to his advertence. Anta case. We don't agree with brother Sunil Dutt Yadav.
Please, I just add one more vital fact. As I pointed out, my lords, I pointed out about the death on 28/11/2023.
By that time, it was expired.
Yes, but I'm not, what happened thereafter, my lords? The impugned assessment order was passed thereafter by the department in the name of the deceased SSC. That is what I challenged before this honorable court. The subsequent order, after him becoming aware of the fact of the death of the SSC, he still passes it in the name of the deceased
That
SSC.
cannot be.
That is the point. That is the
Correct.
point.
That
I appreciate that the original notice may still serve, that is still a question which can be left open. But after I've 3 separate times told him that he has passed away, this is the death certificate, he still proceeds to pass the order, issue demand notices in the name of the deceased. That would not survive. And now the limitation to pass an order pursuant to the original notice
Your power
would
to,
not.
your power to levy tax is power against a person. Definition of person may be wider than what Salmon says. It may be wider. Partnership firm may be a person, estate may be, idol may be. All these things are different. But once you come to know a natural person is dead, you could not have passed because assessee is not available. Notice to assessee, not notice to the estate of the assessee. Section is not that way. Notice to assessee means notice to assessee who is living, not a dead. To that extent, he is right. You could not have passed the assessment order against the dead person at all. You could have made the issued notice to them. Then you could have done this, that other exercise is another thing. But this order appears to be sensible. We understand the difficulty. We understand your difficulty. We understand the difficulty of the citizen also. Both we understand. As between difficulty of the crown and the citizen, citizen's difficulty is given some credence because crown is capable of withstanding those
My lord,
things.
my last submission would be, my lord, the legal representative, my lord, having stepped into the shoes of the deceased as a legal representative under section
Read section
159(3).
140.
159(3).
ಬೇಡ ಮೊದಲಿಗೆ ಇದಕ್ಕೆ ಹೋಗಿ 148AB ಓದಿ. ಅಲ್ಲಿಂದ ಇನಿಷಿಯೇಟ್ ಆಗತ್ತಲ್ಲ.
Please.
148AB contemplates notice to the assessee.
SSC.
He is dead.
He's dead, my lord, at the same time, my lord, the deceased would be represented by the legal heirs. I mean, legal representatives.
But you passed an order against the dead man now.
Please, my last submission would be, at the time of issuance of 148AB, my lord, the SSC was no more.
Correct.
And my lord, the legal representative was duty bound to inform, having received the notices, both 148.
He informed you. He is dead ಅಂತ ಹೇಳಿದ.
That can an date later.
ಯಾವಾಗ?
On 28/11/2023.
Correct. ನೀವು ಫಸ್ಟ್ ನೋಟಿಸ್ ಕಳಿಸಿದಂಗೆ ಅವ್ನು ಪೋರ್ಟಲ್ ಕಳಿಸಿರಿ. How they will know? This is has gone now. He has gone with the wind. How they will be able to open his portal? ನೀವು ಎರಡನೇ ನೋಟಿಸ್ ಫಿಸಿಕಲ್ ಕಳಿಸಿದಾಗ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ನಿಮ್ಗೆ ಇಲ್ಲ ಅವರು ಎಕ್ಸ್ಪೈರ್ ಆಗಿದ್ದಾರೆ ಅಂತ.
Lord, we were required to send it by, my lord, electronic communication, my lord, as per the notice.
Correct.
I mean, as per the.
ಅಲ್ಲ, you have complied with law, but that it is like saying the surgeon has conducted the surgery in accordance with rules of surgery, but patient is dead ಅಂತ ಹೇಳ್ದಂಗ. Your law does not provide for that eventuality. At least it should have said, notice to deceased shall be treated as notice to elders of the deceased who represent his estate. Such a provision is not there. We understand the difficulty, how you should have thought over this and. But anyway, after they informed you that he is dead and gone, you could have taken action against them, not against the dead person. It is like grabbing the other gori and thing. The tomb will not answer unless there is a ghost.
And just to add one, I'm not impugning the 148 notice issued on in the writ petition also. I only challenge the assessment order which was passed after I've intimated.
It cannot be.
That order is passed in the name of the deceased. That was my primary submission.
Dismissed, agreeing with the reasoning of the learned single judge. However, liberty is reserved to the department to initiate proceedings against the LRs of the deceased assessee in accordance with law.
On that, there's a limitation also for them that.
In accordance with law, if it is available, they will take that. We do not know. That will not say anything.
Take for one section is there with respect to the limitation to pass the order. Then may I please place the decisions of the Gujarat High Court.
Anyway, we cannot block that because it will have a lot of consequences tomorrow.
That question itself has arisen before the Gujarat and Delhi High Court.
We are giving liberty, but we are dismissing the appeal. Whatever they want to do, let them do.
That would not be permitted in law, Maharaj, because the section.
We do not do. Therefore,
in accordance,
if law permits, sir. If law permits.
Subject to limitation, my lords observes it.
Will not say anything. If law permits, limitation is also law only.
I appreciate that. May I just point out one section because in effect, my lords have allowed the writ appeal without hearing me then.
Allowed the? No, we are dismissing the writ appeal.
But my lord says that the liberty, that is what they are assailing the writ
No, we are entitled to, otherwise.
No, if the liberty.
One case.
My learned friend is filed a writ appeal challenging the liberty granted.
Correct.
I have serious grievances against that because the law does not permit. There are 5 decisions.
We are saying if law.
Then
now,
let me please place
you
the
are
decisions on
protected.
record.
You are protected now.
I'm not protected, my lords. If my lords observes liberty is granted, they will definitely initiate, and that is not permitted in law, permitted by judgments also.
Therefore, we are saying
yes,
liberty is reserved to them to take appropriate action if law permits. Why we should say whether law permits or not? That debate will not undertake now at this stage.
If the learned single judge's finding says there is no liberty, if my lord says if liberty is there, then my lords have in effect set aside the learned single judge order without hearing. Without reason. Then I'm ready.
No, that may not be because
no, what he
learned
says
single judge has only said, my lord, in law. So my lordship also is telling if the law permits only, it can be issued.
No.
He is saying, what he says is, whatever little benefit the learned single judge has granted, that we may not tinker to his disadvantage, is his contention. Let us see what is the point he will make. But
we'll just read out the learned single judge.
What the learned single judge has said?
Page 13.
Page 13.
1-3.
Yes, page 12 may be seen because the findings start from of the writ appeal.
No, while allowing the petition,
please.
What about the liberty he has mentioned?
Liberty
because your argument is only as to liberty should be given or not.
That is on page 13.
Page para?
Para 9, Maharaj. May I read? In the light of the above, question of continuing with fresh proceedings against the deceased, which liberty sought for by the learned counsel for revenue, would be permissible only if proceedings could have been taken against the deceased if he had survived. The present proceedings under 148 as regards assessment of 1670. The time limit for the proceedings under 148 would be in terms of the proviso under 140 and 1B. In terms of the proviso, there is a bar for issuance of notice under 148 in a case for a relevant assessment year before 148.
What is the amount involved?
It is above 50 lakhs. There is no
50 lakhs.
Yes.
5 crores.
Huh?
It is, my lord, amount payable.
5 crore.
1 crore
44 lakhs.
That is
1
the
crore
demand.
44 lakh.
That is the demand.
Okay.
Inclusive of interest.
Okay.
And proceedings would have been initiated within 31/3/23 within the outer limit of 6 years from the end of the assessment year 1670 as against the legal representative. Accordingly, at this stage, while setting aside the notice under 148, question of granting liberty would be contrary to the mandate of time prescribed under 149 and 1B proviso. No doubt it is the contention of learned counsel for revenue that intimation, if given within time, the revenue would have initiated fresh proceedings against the LRs. However, taking note of the decisions in Alamelo Veerappan Madras High Court, Savita Kapila Delhi High Court, we find that there is no support for the contention that there is a statutory obligation on the deceased to intimate the department. The observation made at para 32 in the case of Savita Kapila requires endorsement in the present case also. Accordingly, by setting aside the notice issued under 148 and the orders pursuant thereto, including the assessment order, annexure A1, computation sheet and demand notice and penalty notices are set aside. The consequential proceedings, if any, raising demand are also set aside. Accordingly, petition is disposed of.
How Alamelu and Savita Kapila,
Please.
they proceed, just give that judgment. But
Point out the relevant dates because the death and the notice are only relevant in this. The death, my lords, will notice at para 3 on page 3, my lords.
para 3
On page 3, at the top.
the division bench, single judge.
This is single judge, my lords,
Single judge.
which has followed 2 division benches.
How single judge treats that?
Yes, yes. My lords, may kindly turn to para 15, my lords, which is on page 5, the second last. Para 14, just above that, is the question which was framed by the Honorable Court. The issue, my lords, had the issue which falls for consideration, para 14.
Yes, the issue which falls
Falls for
consideration is to
as
the
to whether the impugned notice under 148 issued in the name of the dead person, so and so, is enforceable in law, and the subsidiary issue being as to whether the petitioner, being the wife of the said so and so, can be compelled to participate in the proceedings and respond to the impugned notice. The fact that Shri so and so died on 26/1/2010 is not in dispute. If this fact is not in dispute, then the notice issued in the name of the dead person is unenforceable in the eye of law. The department seeks to justify their stand by contending that they were not intimated about the death of the SSC, that the legal heirs did not take any steps to cancel the PAN registration in the name of the SSC, and that therefore the department was justified in directing the petitioner to cooperate in the proceedings pursuant to the impugned notice. The settled legal principle being that a notice issued in the name of a dead person is unenforceable in law. If such is the legal position, would the revenue be justified in contending that they, having no knowledge about the death of the SSC, are entitled to plead that the notice is not defective? In my considered view, the answer to this question should be definitely against the revenue. This court supports such a conclusion with the following reasons. Admittedly, the limitation period for issuance of notice for reopening expired on 31/3/2017. The impugned notice was issued on 30/3/17 in the name of the dead person. On being intimated about the death, the department sent the notice to the petitioner.
To the widow.
That is to the LR.
Widow.
I'm sorry, ma'am.
To the widow.
To the widow, yes, to that, yes. Ma'am.
That is after the expiry of the period itself.
Yes, yes. Identical facts, in fact, but there they sent it again in the deceased, in my case. In my
They
case.
did not send it to you, but again in the name of the dead person notice.
Yes, yes. I'm sorry, this notice was well beyond the period of limitation as it has been issued after 31/3/17. If we approach the problem sans complicated facts, a notice issued beyond the limitation period of 31/3/17 is a nullity, unenforceable in law and without jurisdiction. Thus, merely because the department was not intimated about the death of the SSC, that cannot by itself extend the period of limitation prescribed under the statute. Nothing has been placed before this court by the revenue to show that there is a statutory obligation on the part of the LRs of the deceased SSC to immediately intimate the death of the SSC or to take steps to cancel the PAN registration. In such circumstances, the question would be as to whether 159 of the Act would get attracted. The answer to this question would be in the negative, as the proceedings under Section 159 can be invoked only if the proceedings have already been initiated when the SSC was alive.
When he was alive, they should have issued the notice to him. If he dies thereafter, then they can proceed against the LR.
Yes.
That is the
purport of this precisely. Would be when the SSC was alive and was permitted the proceedings to be continued against the LRs. The factual position in the instant case being otherwise, the provisions of 159 have no application. The revenue seeks to bring their case under Section 292. This may not, I'll read that. Seeks to bring their case under Section 292 of the Act to state that the defect is a curable defect, and on that ground, the impugned notice cannot be declared as invalid. The language employed in Section 292 is categorical and clear. The notice has to be in substance and effect in conformity with or according to the intent and purpose of the Act. Undoubtedly, the issue relating to limitation is not a curable defect for the revenue to invoke Section 292B of the Act. All the above reasons are supported by the decision in the case of Vipin Walia, Supra, it's a Delhi High Court. In that case, the notice dated 27/3/15 was issued under 148, who died on 14/3/15. The validity of the said notice was put to challenge. The ITO took a stand that since the intimation of the death
that was also notice after death.
Notice after death. All the cases are notice after death. I'm sorry. was not received by her, the notice was issued on a dead person. However, the fact regarding the death of the SSC could not be disputed. The department continued the proceedings under sections 147, 148, and at that stage, the son of the deceased approached the High Court of Delhi. The High Court of Delhi pointed out that what was sought to be done by the ITO was to initiate proceedings under 147 against the deceased SSC for assessment year 8-9, for which the limitation of issuance of notice under 148 was 31/3/15. And on 2/7/15, when the notice was issued, the SSC was already dead, and if the department intended to proceed under section 147, it could have done so prior to 31/3/15 by issuing the notice to the LRs of the deceased, and beyond that date, it could not have proceeded in the matter even by issuing notice to the LRs of the SSC. The decision Vipin Walia fully supports the case of the petitioner herein. The decision in the case of Vipin Walia was followed in the decision of the Gujarat High Court in the case of Rasid Lala, in which the reassessment proceedings were initiated against the dead person, that too after a long delay. The court pointed out that even if the provisions of 159 are attracted, in that case also, the notice was required to be issued against and in the name of the heirs of the deceased SSC, and under the said circumstances, section 159 of the Act shall not be of any assistance to the revenue. In the decision of the Delhi High Court in the case of Spice Entertainment, one of the questions which fell, that was actually with respect to a company which is amalgamated. I'll read it this for us. Is as to whether framing of assessment against a non-existing entity or a dead person could be brought within the ambit of 292 of the Act. And after referring to the decisions on the point, including the
No,
decision.
that cannot be brought into
Yes,
it.
that is not.
Where is the appellate decision against this?
Sorry, ma'am.
This did not go in appeal.
Not appeal.
This single judge only.
Not appeal.
Which are the division bench judgments on the identical point?
Yes, I'll just place the Delhi High Court, ma'am, the latest one. Rajendra Kumar Sehgal.
Correct.
Yes, Manoj, may kindly turn.
Sehgal.
Yes,
Para?
para 3, Manoj, on the page number 3, at the bottom of page 3, Manoj.
Page 3.
Yes.
Para 3.
At the bottom, yes, ma'am. Just the issue which has been, which arises for consideration. The petitioner approached this court seeking the reliefs that he has claimed primarily on 3 grounds. Firstly, the Act does not provide any mechanism for issuing and carrying on reassessment in respect of a dead person if the reassessment notice is issued against a deceased. Second and third are on other jurisdiction issues.
Only this aspect is considered where?
Yes, my lord, may kindly turn to the following page. Analysis and conclude in the middle of the page. It's in italics.
Correct. The provisions relevant
Is
to
extract.
decide the first issue is section 159 of the Act, which reads as under.
Then on the following. 159(2)B is the
159(2) for the purpose of.
yes, for the purpose of making an assessment, including assessment, reassessment or recomputation under 147 of the income of the deceased, and for the purpose of levying any sum in the hands of the legal representative in accordance with the provisions of subsection 1. A, any proceeding taken against the deceased before his death shall be deemed to have been taken against the legal representative.
Provided they take action before he dies.
That, I'm sure that would not apply.
Correct. That is
Yes.
not the case.
He is-
Proceeding itself is time barred is his version.
And
But when they issued first notice,
Yes, ma'am.
it was to the portal,
It was not time
not to
bound.
this person.
That was well within time.
Correct.
Yes, yes.
But how they will know ಅಂತ ಅದು ಈ ನೋಟಿಸ್ ನೀವು ಕಳಿಸಿದ್ದು.
In fact, even now I don't have.
Lord,
a
how
copy of
we
that
will
notice.
also know.
Of course, we understand. For that, you
Lord,
should have made
three-
law.
2-3 notices. My lord, that's why, my lord, my humble submission would be, as a legal representative, my lord, at the time of the death, when he inherits all the other things, even the responsibility as a deemed SSC would also fall on him.
Deemed assessee ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ.
Deemed SSC
definition.
159(3).
No, that is deemed assessee ಅಂದ್ರೆ notice to the assessee shall not be deemed to be notice to deceased assessee shall not be deemed to be notice to the LRs of the deceased assessee. That is his contention. For all practical purposes, he will be standing in the shoes of deceased assessee, provided you give notice to him, and that notice to be within the limitation period and our contention. Anyway, let us see. Wait. What you say is there is a deadlock, whole section dalli ಅದೆಲ್ಲ fit in ಆಗೋದೇ ಇಲ್ಲ ಅಂತ. They should have made a provision.
When we issued notice, my lord, we were ignorant that he is no more.
Correct. He says there is no
Peter,
duty
Lord.
cast on the citizen to report death to the crown anta. ಅದಕ್ಕೆ ನಿಮ್ಮ ಆ ಡ್ಯೂಟಿ ಇಟ್ಟಿದ್ರೆ
My lord, ಆ ಡ್ಯೂಟಿ ಇರಲ್ಲ ಯಾವಾಗ ಅಂದ್ರೆ when there is no proceeding at all against the SSC. 159A, first, my lord, 159 2A. 159 2A, if it is so, that is right.
any proceeding taken against
Taken against the SSC.
he seized before his death shall be deemed to have been taken against the legal representative. ಅದಲ್ಲ ನಿಮ್ ಕೇಸು.
No, if there was no notice, no proceedings at all, he is not under duty to inform.
Correct.
If there is a notice, which of course has been sent in the name of the dead person, because the department is not aware. My lord, we are in a very different situation.
ಅಲ್ಲ you should have made law. ಇಂಥ ಸಿಚುವೇಶನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಿಂದ ನಮ್ ಕೈಯಿಂದ ಲಾ ಮಾಡಿಸೋ ಬದ್ಲಿ the parliament should have thought over.
My lord, may I seek one short time, my lord, just to see how it has been served on, my lord, 158AB.
ಅಲ್ಲ ಹೇಳಿದಾರಲ್ಲ ಅವರು ನೀವು ಮೊದ್ಲಿಗೆ ಕಳಿಸಿದ್ದು ಈ ನೋಟಿಸ್ ಅದು obviously ಈ ನೋಟಿಸ್ ಬಿಕಾಸ್ ದಿ ಸೆಕ್ಷನ್ ನೀಡ್ಸ್ ದಟ್ ವೇ.
Yes.
ಸೆಕೆಂಡ್ಲಿ ಅವರು ನೀವು ಅವ್ರ ನೋಟಿಸ್ ಕಳಿಸಿದ್ದು ಅವ್ರು ಹೇಳಿದ್ದು ಡೆತ್ ಆಯ್ತು ಅಂತ.
During the time of assessment.
ಅವಾಗಾದ್ರೂ ಇವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋದು ಅವಾಗೂ ಟೈಮ್ ಬಾರ್ ಆಗಿಬಿಟ್ಟಿತ್ತು ನಿಮ್ ಕೇಸ್ನಲ್ಲಿ ಇನ್ ದ ಗಿವನ್ ಕೇಸ್. Anyway, we have understood now. Any other thing you want to see?
Just one crucial. All these decisions are not question about whether the notice under 148, if issued to the deceased SSC originally within time, can they, if they subsequently issued to the LR subsequently, will that still be in time? My case is, for instance, Manoj, in this case, the original notice to the deceased was within limitation, no doubt about that. It was issued to the deceased, that is one aspect of the matter. Ultimately, Manoj, the notice to me, to the LR, was not issued at all after I intimated him about the death. The assessment order was still passed in the deceased name. Now, the limitation to pass an assessment order after 148 notice, that has lapsed. Had he passed the assessment order in the LR's name, I could not have come before this honorable court at all.
At least after you inform them death of your
148 notice, maybe I'm not even really getting into that, Manoj, because that may be on a different footing. Because yes, he may not have been aware, the question of whether I have a right to inform, that can be considered another, perhaps another petition where the facts are germane. In this case, 148 notice, let us assume that issued to the deceased is all right. But when I informed him about the death,
ಅವಾಗಾದ್ರೂ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಡಬೇಕು.
then he passes the order in the name of the deceased.
ಅಲ್ಲ ಅವಾಗೂ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಂಗಿರ್ಲಿಲ್ಲ. ಏನಾಗಿತ್ತು ಆ ಟೈಮ್ಗೆ ಎಕ್ಸ್ಪೈರ್ ಆಗಿಬಿಟ್ಟಿತ್ತು ಲಿಮಿಟೇಷನ್.
Now he cannot pass that order.
ಅಲ್ಲ ಆರ್ಡರ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಬಿಡಿ.
That is what I'm
So far as order is concerned, over. Now we are thinking but the liberty to proceed against the DC, the LRs of the DC who have taken the estate of the SSC after his demise. Our death is a complete immunity ಅನ್ನಂಗ ಆಗತ್ತೆ ಅಂತ ಒಂದು ವ್ಯೂ ಅಲ್ಲಿ ನೀವು ಅನ್ನೋದು if policy of the law is that way, it should be allowed to be that way only ಅಂತ ನಿಮ್ contention.
The law has to be read in a strict sense because they specifically, if a vicarious responsibility is being cast upon a deceased SSC, upon the LRs of a deceased, should that be construed in a strict manner or liberally so as to benefit the revenue or me especially?
Vicarious liability ಇಲ್ಲ ಇಲ್ಲಿ.
In
It is a liability, of course, in a way that sounds that way. You are the liability to pay tax is fastened to the estate of the deceased, which you are holding. You are holding that way.
I fully bought on. If I am tasked with the responsibility to pay the tax liable to be paid,
not you.
Yes.
If the estate of the deceased is liable to pay,
yes,
ಅಂತನೂ argue ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. But what you say is it has rightly or wrongly has come to my hands. If you want to proceed against me, that there is a legal method. Only that method is permissible, not otherwise.
And just one additional point was, if learned single judges order in other case, which I first placed reliance on, and the Madras High Court has not been appealed, the Supreme Court has held time and again if the revenue in similar facts and similar law
does not appeal
in one case, then there should be prevented from filing appeal in other case. I'll place that also on record. They cannot accept in one case and then challenge in my case.
Like Kusum Ingot.
Yes, Kusum Ingot is one of the cases. Yes, ma'am.
Have they mentioned that?
That's also been mentioned. Yes, this is Amar Bitumen, which says refers to a number of decisions.
My lord, all these decisions are, my lord, prior to, my lord, that law which was brought in for the issuance of 148A. 1/4/2021.
1/4/2021.
These are all before that, wherein, my lord, directly 148 will be issued.
No, one of them is also 148. Again, the point is. Court, the सभी का कपिल है 140. Para 5 में kindly be seen. May I read, ma'am? This court-
Earlier order, if you are not appealed, it binds ಅನ್ನೋ ರೀತಿ ಇದೆ ಅದು. If you are not appealed against that order, that itself binds you ಅಂತ. But this was all a pre-amendment, Richie.
But this is this is a settled position regarding the amendment is with respect to the procedure for reassessment. That has nothing to do with
With
whether.
deceased and LRs.
Yes, yes. The
ಆ
position
provisions intact ಆಗೇ ಇದಾವಂತನಾ?
is with respect, these are with respect to the settled position that the revenue cannot pick and choose, regardless of the provisions for procedure for reassessment. Ultimately, ma'am, I did not, I'm not impugning the 148 notice. In the writ petition also, the prayers may kindly be seen. I have only impugned the assessment order passed after me informing the department about the debt.
No,
That-
in that broadly, perhaps we are in agreement. What should happen otherwise? By death, can one be immune from legal proceeding? There is one in Broom's legal maxim. There is such a maxim which says, death per se is not an umbrella against the proceedings at the hands of the crown ಅನ್ನುವಂಥ ಒಂದು Latin maxim ಇದೆ.
Note, I'll examine.
ಈಗ suppose if you take estate of the deceased, ನಾವು ಇದ್ರ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ಇಲ್ಲ. ಇದರ ರಿಪರ್ಕಷನ್ಸ್ ಏನೇನಿದೆ, we have to think and we have to pass the order. ಅಲ್ಲಿ ಅಲ್ಲಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಇತ್ತು? ಡೆಲ್ಲಿ ಇದು ಮಡ್ರಾಸ್ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಅಮೌಂಟ್ ಇನ್ವಾಲ್ವ್ ಎಷ್ಟಿತ್ತು? ಸ್ಮಾಲ್ ಅಮೌಂಟ್ ಇದ್ರೆ ಅವ್ರು ಅಪೀಲ್ ಮಾಡೋದೇ ಇಲ್ಲ. ಅದ್ಯಾವುದೋ ಒಂದು ಪ್ರಾವಿಷನ್ ಇದೆ ಅಲ್ಲ.
That is for statutory appeals, not for, it doesn't apply for writ petitions.
ಇದಕ್ಕೆ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
Doesn't apply. That is a monetary limits for statutory appeal. Writ petitions, specifically the circular exempts writ petitions and writ appeals from that. So even if the amount involved is 1 rupee, if the question of law in a writ petition is raised, the department is not stopped from filing an appeal. Let me put it like that. There is no negative restraint placed upon the department to assail a writ petition order merely because the tax effect there.
I think there is one judgment of the division bench, my lord, where they said monetary limits are applicable for writ appeals.
ಅಂತ ನಾವು ಒಂದು ಹೋಲ್ಡ್ ಮಾಡ್ದಂಗಿದೆ.
My lord will take it up day after. Today I'll just examine that also. I'll just see, but.
ರಿಸರ್ವ್ ಮಾಡ್ತೀವಿ, ನಿಮ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ಸ್ ಕೊಡಿ.
Please. My lord,
Heard,
I am
reserved.
only on a limited point, my lord.
ಲಿಮಿಟೆಡ್
When-
ಪಾಯಿಂಟ್
ಅಲ್ಲ,
ಅಂದ್ರೆ
limited point,
ಅದರ್
can
ಆಸ್ಪೆಕ್ಟ್
it
ನಲ್ಲಿ we
not
may
be
not interfere.
can it not be construed?
Learned single judges ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. To the extent whether liberty should be reserved to the department or not ಅನ್ನೋದು the greater consideration of other things. Perhaps we do not know. When we sit for drafting the judgment, we'll know. But prima facie, we feel the reasoning of the learned single judge for the invalidation of the order which you have passed against the dead person.
Correct.
After knowing that he is dead, perhaps perhaps we do not know. We feel like that way. Since
No, I'm
he
not
arguing on
I'm not arguing on that point.
But that is the only thing,
I'm-
in the petition, I've only impugned the order. I have not impugned the
Initiation.
148 notice at all. So my learned friend is arguing technically in a vacuum. If I.
No, but the court said,
Yes.
since you argue no liberty can be
Yes.
this one,
No, but
that aspect requires consideration
I appreciate.
in our.
Yes,
plea.
no, my only humble submission my lord, is that if liberty to do what is my only question, because the assessment order has already been passed in the name of the deceased SSC after.
So that has been set aside because on the ground that they are non-honest.
Yes.
If it is the ground of non-honest, they do not exist in the eye of law. Therefore, you can't say that assessment orders, reassessment orders have been passed. This is how Wade and Forsyth in their administrative law say, right? Where court records a finding, they call it as a magistra dicta in Latin. Once there is a magistra dicta to the effect that an order of an authority is non-honest, then for all practical purposes, that order does not exist in the eye of law. On that premise, this judgment is structured. even reasoning of the Madras High Court and Delhi High Court, they are structured on that premise only. If it is a case of no order, then whether liberty should be reserved or not, in the light of that, we have to decide, keeping in view several provisions of the act, only that aspect. Whether that should be applied to you or not, also we may, whether it should apply to, because for the first time we'll be saying that that should not reopen Pandora's box and other things. That also we are thinking that way. Let us see. ನಿಮ್ಮ written submission ಕೊಟ್ಟಿರಿ. ಸ್ವಲ್ಪ ಟರ್ಸ್ ಆಗಿ ಬರೀರಿ.
I'll file it.
ಅದಕ್ಕೆ.
Yeah, just one last section just for the benefit of my, with respect to limitation to pass a reassessment order after 148 notice. The notice in this case was issued on 13/3/23. Assume that it is permitted to be issued in the name of the deceased. I'm not even questioning that. The time limit for them to pass the order after the notice is 12 months from the end of the month in which the notice was issued. Notice issued.
ಆ period ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಆ period ಹೋಯ್ತು. So if my lords were to assume, were to say liberty if permitted in law also, they've passed.
Even then they cannot pass order.
Because the order which I impugned was passed within those 12 months, but in the name of the deceased, after I informed them. So if, in effect, if my lords were to say liberty if permitted, they would then now get a second innings to pass an order in the name of the LRs when they had already bypassed. That time was over. And after being aware of the fact.
But proceedings were pending.
Proceedings were not pending.
Not pending.
Not pending. The
Even before that, it has expired.
Yes. The assessment order in this case, my lords, was
No,
passed on.
assessment order was passed in time.
It's passed in time, but in the name
Time.
of the deceased.
That is non-est only now.
That is what. So now.
So no order is passed.
No order is passed. Now, if my lords were to permit them to assume that they were to take from my lords' words that they have the liberty to initiate fresh reassessment order, that would be time barred again. Not just under the deceased provisions, under the separate limitation provisions also. They would be hit twice.
ಅದ್ಯಾವುದು ಆ provision ಯಾವುದು?
153 may kindly be seen.
153 is treated by Justice Ravindra Bhatna.
Yes, that is, yes, please.
It is treated.
In a different.
Of course, in a bit different context.
Please. My lords may kindly turn to page 1.1040.
One point
1040. Of the income tax act.
One point
1040.
1.1040.
On the left of the book, left side.
You are right.
I just, subsection 2 may kindly be seen now. This section, my lords, is with respect to limitation to pass various orders under the act. 153(2) may kindly be seen.
No order of assessment.
Yes, no order of assessment,
Reassessment, recomputation
shall be made under 147.
after the expiry of 9 months from the end of the financial year in which the notice under section 148 was served.
The proviso is applicable, my lords. Provided that where the notice under 148 is served on or after 1/4/2019, even assuming it is served in this case, the provisions of this subsection shall have effect as if for the words 9 months, the word 12 months had been substituted.
Only 3 months will be extra.
3 months extra.
Even that period will be over.
That period. So what I literally want, notice was issued, assume it is served.
No, you cannot say notice issued because it is no notice at all is the law. Notice to dead.
Please.
Is notice to the tomb. Notice to tomb is no notice anta hold ಮಾಡಿದ್ದಾರೆ.
Yes.
English court.
Yes. Even for a moment, if I were to concede that that is a notice assumedly served also for the.
Still it will be worse ಅಂತಾನೆ ನೀವು
The notice would be issued, served in March 2023. 12 months would be March 2024. The order which I impugned to the petition was passed on 29th March 24. But now, my lords, if they were to, but in the name of the deceased SSC, after I've told him 3 times in the November 2023, December 23. So now if you were to again reopen the proceedings.
If the pendency of the proceedings, the principal section 14
Yes.
of Limitation Act is extended to other branches of law by the Supreme Court. If proceedings are bona fide prosecuted in a court which has no jurisdiction.
Yes. That has to be excluded, yes.
That needs to be excluded. It is not only court without jurisdiction. Inappropriately taken up proceedings anta hold ಮಾಡಿದ್ರು ಧಾರವಾಡದಲ್ಲಿ, and it is affirmed by the Supreme Court now. Therefore, ಅದನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ರೆ ಏನಾಗ್ತದೆ ಅನ್ನೋದನ್ನ ನೋಡ್ಬೇಕಾಗ್ತದೆ. ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಕೊಡಿ ನೀವಿಬ್ರು. ದರ್ ಇಸ್ ಅ ಲಾರ್ಜರ್ ಇಶ್ಯೂ. If at all we hold that rejecting his contention, but how can his client be punished is another point. At the most we can say, we're just thinking, we are only thinking aloud. We are not concluding anything. There is a lot of scope for thinking now.
She's also the LR, what I mean, may not be relevant, but I should also, I'll be failing my duty to point out. She is a 23-year-old. Her father is the one who's passed away. Mother also passed away, both tragically within 6 months. So to cast fault on her, to not intimate the income tax department when there were no proceedings pending. I understand if a notice had come.
No fault at all. Because law does not impose a duty to inform.
Yes. So in the absence of a duty, can the law of limitation now provided under the section, and 159(3) says all the proceeding provisions of this act shall apply accordingly. Why was that enacted? Because to ensure that something which could not have been done otherwise under the act, it should not be saved now merely because of the death of the SSC. 20 years later, if they wake up and realize, they should not say, oh, he's passed away, so now I'm issuing the notice. The reason why 159(3) was also provided for is to ensure that certain rights and liabilities or responsibilities.
And the law of limitation is a law of repose.
Yes.
Peace and repose. ಅದು ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತದೆ ಅಂತ ನೀವು ಅನ್ನೋದು. ಆಮೇಲೆ ಒಂದ್ಸರಿ ನಾವು ಲಿಬರ್ಟಿ ಕೊಟ್ಟದ್ದು ಯಾವ ಎಕ್ಸ್ಟೆಂಟಿಗೆ ಹೋಗ್ತದೆ ಅಂತನೂ ಗೊತ್ತಿಲ್ಲ. ಈ ಆಸ್ಪೆಕ್ಟು ಇದೆ. ಇತ್ತೀಚೆಗೆ ಬಂದಂತ ಟಫ್ ಕೇಸ್ ನೋಡಿ ನಮಗೆ. ಅದು ಬೋತ್ ಯು ಹ್ಯಾವ್ ಆರ್ಗ್ಯೂಡ್ ಸೋ ವೆಲ್.
May I just take the courage to just make one submission? In fact, the learned single judge, while dealing with this submission, to be fair, has not actually examined this at length. I should also point that out. What happened was, I was my learned friend.
Since an order of assessment was made on dead person,
yes,
he said it could not have been done.
In fact,
but to some extent he has treated.
Yes.
Whether liberty should be reserved or not, melenu treat ಮಾಡಿದಾರು.
Yes.
Yadav, Justice Yadav is a national law product and one of the best judges of this court.
What had transpired since we were there is actually a question was posed to the standing counsel department, not my learned senior friend, another member of the panel was, "Eeg madboda anta," that was the question posed. And it was said, "Eeg agala." And I think that was, so perhaps, and the point about 153(2), which I read to my lords about limitation to pass the order under 147, being within 12 months from the issuance of notice. That aspect, although canvassed in the writ petition, was not at length. And in fact, I have not impugned the 148 notice at all. What I impugned in the writ petition was the order passed in the name of the deceased SSC after I intimated. That is also something which my lords may have the benefit of, just as a suggestion. Because ultimately in appeal, my lords are sitting, if the reasons perhaps are not as forthcoming as ideally, just to be fair to my little friend, I thought I should point that out.
ಆಲ್ ರೈಟ್, ನೀವು ಇಬ್ರು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಕೊಡಿ, ನೋಡೋಣ ಏನ್ ಮಾಡ್ಬೋದು ಅಂತ. ಬಹಳ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಇದೆ. ಅದು ಪಾಲಿಸಿ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಆಗಿನೂ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೋದು. ಇಫ್ ಇಟ್ ಇಸ್ ಎ ಪಾಲಿಸಿ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್, ನಾವು ಜಜ್ಮೆಂಟ್ ಬರೆಯೋದು ಹೆಂಗೆ ಅಂತನೂ ನಾವು ಕೇಳ್ಕೋಬೇಕಾಗ್ತದೆ. ಈಗ ಆ ಪಾಲಿಸಿ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಇದ್ರೆ ಅಷ್ಟೇ ಪಾರ್ಲಿಮೆಂಟಿಗೆ ಬಿಡಬೇಕು, ಅದೇನ್ ಮಾಡ್ತದೆ ಅನ್ನೋ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ ಅಲ್ಲಿ. ಅದು ಪಾಲಿಸಿ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಅಲ್ಲ, ಬಟ್ ಇಟ್ ಫಾಲ್ಸ್ ವಿದಿನ್ ದ ಪೆನಂಬ್ರಾ ಆಫ್ ದೀಸ್ ಪ್ರಾವಿಷನ್ಸ್. ಅಂದ್ರೆ ನಮ್ಮ ಇಂಟರ್ಪ್ರಿಟೇಟಿವ್ ಪ್ರೊಸೆಸ್ ನಿಂದ ನಾವೇನಾದ್ರೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಇಂಥ ಕೇಸ್ ಹೆಚ್ಚು ಇಲ್ಲ. ಹಾವು ಪಾಲ್ಕಿವಾಲಾ ಇವರೆಲ್ಲ ಹೆಂಗ್ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ ಇಂಥ ಕ್ವೆಶನ್ಸ್.
Usually that question of liberty being granted to proceed, I think what was arising is the original notices were being issued well before the lapse of limitation. So
ಅವಾಗ ಈ ಪ್ರಶ್ನೆ ಹೇಳ್ತಿತ್ತು. ಅದರ because that itself is against. But question is, he is saying the original notice sent to portal, e notice was within time anta.
No dispute.
And he was alive. No, he was not alive, but it was sent in time that way.
Notice as well as a subsequent order before the issuance of 148.
ಅಲ್ಲ ಕರೆಕ್ಟು. ಈಗ ಅಲ್ಲಿ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಇತ್ತು ಅಂದ್ರೆ ಅದನ್ನ ಕಂಡೋನ್ ಮಾಡಿಕೊಳ್ಳಿಕ್ಕೆ ನಾವು ಪ್ರಾವಿಷನ್ ಇದೆ CPC ಅಲ್ಲಿ. ಇದಕ್ಕೆ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳೋದು. ಅದು ಕಾನ್ಶಿಯಸ್ಲಿ ಮಾಡಿರ್ತಾರಂತ ಕಾನೂನು. ಅಲ್ಲಿ ನೀವು CPC ಪ್ರಾವಿಷನ್ಸ್ ತಂದು ಇಲ್ಲಿ ಯು ಕೆನಾಟ್ ರೀಡ್ ಔಟ್ ಅಂತ ಅವರು ದಟ್ಸ್ ವಾಟ್ ಹಿ ಈಸ್ ಅಪಿಯರ್ಸ್ ಟು ಬಿ ಯುವರ್ ವ್ಯೂ. ಇಫ್ ಪಾರ್ಲಿಮೆಂಟ್ ವಾಂಟೆಡ್ ಇಟ್ ವುಡ್ ಹ್ಯಾವ್ ಮೇಡ್ ಎ ಪ್ರಾವಿಷನ್ ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್. ಏನೋ ಟ್ಯಾಕ್ಸ್ ಲಾ ಮಾಡುವಾಗ ಬೇರೆ CPC CRPC ಮಾಡಕ್ಕಾರೆ ಯಾರ್ಯಾರೋ ಮಾಡಿ ಹಾಕ್ತಾರೆ ನಡೀತದೆ. ಟ್ಯಾಕ್ಸ್ ಲಾ ಮಾಡುವಾಗ ಬಹಳ ಮಿಟಿಕ್ಯುಲಸ್ಲಿ ಮಾಡ್ತಾರೆ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಎ ಮ್ಯಾಟರ್ ವಿಚ್ ಟಚಸ್ ಮನಿ. Government is also as greedy as individuals, if not more. Of course, because as of necessity, in Adam Smith in his Wealth of Nations, he writes that way. If it is policy content ಇತ್ತು ಅಂದ್ರೆ ನಾವು ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅನ್ನೋದು ನಿಮ್ದೊಂದು ವಾದ.
Yes.
ಅದನ್ನೆಲ್ಲ ಸ್ವಲ್ಪ ಎಲಾಬ್ರೇಟ್ ಮಾಡಿಕೊಡಿ. Reserved, heard and reserved. We may not, we feel like this. Again, we are thinking aloud. On the original substance of the order, perhaps my brother judge has written good order. But more focus will be, perhaps, we do not know, more focus will be on liberty should be granted or not. What is meant by liberty now being granted? What are its consequences? By our liberty, you cannot elongate the period of limitation is his contention. Once period itself has gone, don't give such liberty because that gives scope for troubling the citizen anta our contention. He argued very well. Very well. That's her result. Not nimdu ibradu notes ಕೊಡಿ.
Within 10 days, not may be permitted to file within 10 days, not so the written submission. So the written submission is within.
ಆಯ್ತು ಕೊಡಿ. ಯಾಕಂದ್ರೆ ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್ ಮ್ಯಾಟರ್ ಇದೆ, ಅವಸರ ಮಾಡೋದು ಬೇಡ. ಹರ್ಡ್ ರಿಸರ್ವ್ಡ್ ನೀವು ಕೊಡಿ, ಅವರು ಕೊಡಿ, ಇಬ್ರು ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡಿಕೊಡಿ ಅಲ್ರಿ. ಅಂಡ್ ಇನ್ನೊಂದು ನೋಡಿ, ನಮಗೆ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಗಾಟ್ ಪವರ್ ಇನ್ ಗೋಲಕ್ನಾಥ್, IC ಗೋಲಕ್ನಾಥ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಪಂಜಾಬ್ ನಲ್ಲಿ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಈಗ ಲಾ ಮಾಡೋದಿದ್ರೆ, ಇಫ್ ಎಟ್ ಆಲ್ ವಿ ಆರ್ ಮೇಕಿಂಗ್ ಲಾ, ಇಫ್ ಯು ಆರ್ ಇಂಟರ್ಪ್ರಿಟಿಂಗ್ ಲಾ, ವೆಲ್ ಅಂಡ್ ಗುಡ್. If our interpretative process partakes the character of policy making, then whether IC Golaknath will come in the way, adnu nodkondu helbeku. That portion is not diluted by Keswananda. That remains, which is only the prerogative of the Supreme Court to declare law to be prospective in operation. That is not available to the High Court anta one judgment ide, ಒಂದು 2-3 judgment ಇದಾವ ಆ ರೀತಿ. ಅದನ್ನು ನೋಡ್ಕೊಂಡು ಹೇಳಿ. ಸ್ವಲ್ಪ ಈ ಪಾಲಿಸಿ ಕಂಟೆಂಟ್ ಅದ್ರ ಮೇಲೆ ನಾವು ಆರ್ ವಿ ವರ್ಜಿಂಗ್ ಆನ್ ದಟ್ ಅನ್ನೋದು ಸ್ವಲ್ಪ ನೋಡ್ಕೋಬೇಕು, ನೋಡ್ಕೊಂಡು ಮಾಡ್ಕೊಳ್ಳಿ. ವೆರಿ ವೆಲ್ ಆರ್ಗ್ಯೂಡ್, ವೆರಿ ವೆಲ್ ಬೋತ್ ಆಫ್ ಯು. ಖುಷಿ ಆಗ್ತದೆ ಇಂಥ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ರೆ. ಬರೇ 2 ಸೆಕ್ಷನ್ ಓದೋದು, ಮಡ್ಕೆ ಹಂಗಿದೆ ಅಂತ ಹೇಳೋದು, ಎದ್ದು ಹೋಗೋದು, ಕಡಿ ಆಲ್ ರೈಟ್, ದಟ್ ವಿ ಡೋಂಟ್ ಎಂಟರ್ಟೈನ್. ಯು ಆರ್ಗ್ಯೂಡ್ ಸೋ ವೆಲ್, ಬೋತ್ ಆಫ್ ಯು. ಫೆಲ್ಟ್ ಹ್ಯಾಪಿ.
Thank you.
Yes. Yes, Rajendra.
Your Lordship. Is the order passed by the DRAT, wherein DRAT has.
During this vacation,
Yes, my lord.
why did you not write a commentary on DRT law?
It's a draconian law.
Do you feel like that?
Yes, my lord.
The High Court has said that way.
It is a very strict law. Under the pretext of recovering the public money, they have thrown the public policy to the winds, my lord. Because so many lacunas and lapses are there in the securitization which needs amendment. Because at least public money has to be protected. That is the foremost point. But it does not mean at the time of conducting the auction, fixing the reserve price itself is a doubtful. And encouraging the real estate people, first of all, appointing the recovery agents, it has to be curtailed because it gives a signal message stating that are the bank officials are so powerless to recover the amount? Why the recovery agents are being appointed? For them, 7% commission is being debited to my account only.
ಇದೆಲ್ಲ ಕ್ವಶನ್ ಯಾವಾಗ ಹೇಳ್ತದೆ?
And then
ಲೋನ್ ತಗೊಂಡಿದ್ದನ್ನು ವಾಪಸ್ ಕೊಡ್ಲಿದ್ರೆ ಹೇಳ್ತದೆ.
No, see, the subsequently this appointment of the recovery agents were made. The recovery agents concept was not earlier, it was that there.
No, that's all right. All these questions arise when the debtor wants to defraud. If debtor, honest debtor pays back the money, ನೋಡಪ್ಪ ನೀ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀನಿ, ನನ್ ಬಂದಿದೆ ತಗೋ
Yes.
ಇಟ್ಕೋ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ
Yes,
ಇವೆಲ್ಲ ಪ್ರಶ್ನೆ ಹೇಳಲ್ಲ.
ಇಲ್ಲ, your lordship. Suppose funds are diversion ಇದ್ರೆ, misuse ಮಾಡಿದ್ರೆ, end use ಅಂತ ಬರೋದು. ನಮ್ದು those when we are practicing in bank, that is what the end use. Nowadays, they will not insist for end use. Mortgage model, for what purpose you are utilizing the amount, it is not our concern.
Correct.
And EMI concept also is totally bad, because that EMI includes equated monthly installments, means principal plus interest. For that again add penal interest if you commit any default. That is also bad in law. Earlier, we used to, the moment you pay the amount, some portion would have been appropriate towards interest, some portion would have been principal. At least 2 years, 3 years ಆದ್ಮೇಲೆ some principal amount ಹೋಗೋದು interest ಹೋಗೋದು. ಇಲ್ಲಿ more than 3 years, 4 years, 5 years ಆದ್ಮೇಲೆ, even if you see the balance sheet, it shows only our loan account. Even 1 rupee has been credited to my loan account, but the rest only they are recovering the interest. Because of this, and housing loan.
But law says,
Yes, my lord.
under Indian Contract Act, under English law of contract.
Yes.
Chitti on contract right.
Yes.
In a loan contract.
Yes.
Where the loanee makes the payment without specifying whether that should be to the principal or to the interest. It is creditor's prerogative to appropriate that payment either to the principal,
Yes.
or to the
Yes.
interest.
Yes.
That way.
Yes, right.
All these things arise
Yes.
only when debtor is fraudulent. If debtor takes that money and gives back, you had lent to me, take it back.
Yes.
Then all these questions will not arise at all.
Then what is the question? Myself, I'm asking, visa major ಅಂತ ಹೇಳ್ತೀರಾ, earthquake, flood, riots ಅದಾಗ. Because of this COVID situation ನಲ್ಲಿ,
Antad extreme conditions.
extreme conditions.
No, they are different things.
Then the Supreme Court has come down heavily in that Central Bank of India's Ravindra case ಅಲ್ಲಿ. You cannot merge the interest. You cannot compound. You cannot penalize. That statement of account we cannot agitate in Sarpasi Act. ಅವ್ರು ಹೇಳ್ತಾರೆ ಸರ್ಪಾಸಿಲೇನೋ limited scope measures, whether 32 notice is issued, within 60 days you have made payment, followed by possession notice, whether it is affixed, whether paper publication has made, and rule 8.9 says whether complied, valuation has been made, put the property for auction. Simplify, only 3. When such being the case, then where the borrower, genuine borrower, I am canvassing only on behalf of the genuine borrowers who have committed default because of unforeseen circumstances. For example, my lordship permits me. Suppose seize ಮಾಡ್ತೀರಾ property na. The property seized ಮಾಡಿದ್ಮೇಲೆ the court will come down heavily to restore the position of the after 6 years, 3 years, 4 years, whatever it may be. Then the bank says it's a public money has to be recovered. Who is responsible for making payments? 2 crores at the time of seizing the property. After 6 years, they deliver the property to me. For that 6 years, bank debits my watchman WhatsApp, maintenance. Again, interest will also be mounting up. After restoration of the position, who has to bear that interest for the period of 6 years, my lord, for no fault of mine? And the court has upheld the order passed by the DRT, the High Court. Then one more submission, my lord. When we question the very classification of the NPA as a non-performing asset, the court is self-imposed because you are all constitutional authorities, your lordship. You are having inherent powers. We cannot be questionable. And when we approach the Honorable High Court of Karnataka or whatever may be stating that the classification of my account is NPA is not in accordance with RBI guidelines, then immediately court says, no, you have to go to DRT. Yes, we went to DRT in one of the case, my lord, with due respect, with kind apologies, my lord.
Why apology?
No.
If you what you say may be true,
Yes.
we can argue
Then we
also.
went to a DRT. DRT says, yes, the classification is wrong, is bad in law. Agreed by that order, bank prefers appeal before the DRT. DRT says, yes, what the DRT passed the order is correct. Against that order, they came to division bench. ಅದೇನೋ ಕನ್ನಡದಲ್ಲಿ ಒಂದು ಗಾದೆ ಕೊಂಕಣ ಸುತ್ತಿ ಮೈಲಾರ ಬಂದು ಅಂತ. Again, I came to the division bench of this Honorable High Court. Honorable High Court, yes, upheld the DRT order, the division bench order. Then afterwards, my position was restored back. By that time, my this outstanding amount was 8 crores. Whether I am liable to pay that 8 crores, my lord? Whether I am liable to pay the 8 crores? That matter is pending adjudication before the DRT. That is matter is because this Sarpasi Act, yes, Securitization Act, security interest. Then why you are selling my asset to the RCIL? ARCIL?
These are all the policy matters.
Policy matter. We cannot
these
agitate.
things, this is one aspect. If you do not borrow, you will be very happy.
Then one-time settlement, why the discrimination?
anything, anyway, no,
No, because
many aspects ಇದೆ.
No, so many lacunas, so many lapses, my lord.
What is this matter?
Here, very simply, DRT dismissed all my three application, 500 section 17, 13.4, 14, all corrected matter division writ petition is there. My submission is, if it is clubbed together, all the three.
But
The three there.
Call
22689.
ಬರ್ಕೊಡಿ.
Yes, my lord, ಬರ್ಕೊಡಿ.
Call this petition
22689.
along with
22983. 3.
WP number so and so.
All the three.
ಬರ್ಕೊಡಿ. Next week ಹಾಕೋಣ.
Please, my lord. What again? 30th or?
In fact, there is one Sarvagnyas Tripadi.
Yes, my lord.
3 liners.
Yes.
Which we were taught in our primary school. ಸಾಲವನು ಕೊಂಬಾಗ ಹಾಲೋಗರ ಉಂಬಂತೆ ಸಾಲಿಗನು ಬಂದು ಮರು ಕೇಳಿದಾಗ ಕಿಬ್ಬದಿಯ ಕೀಲು ಮುರಿದಂತೆ ಸರ್ವಜ್ಞ. We were taught in our primary school. Our
ಅಂದ್ರೆ
teacher
ಸರ್ವಜ್ಞ also experience about non-performing asset ಆದಾಗ ಏನಾಗತ್ತೆ ಅಂತ.
Next week?
Highly obliged. And I'm grateful to this court for giving me opportunity to place my.
No, just to know how law operates. So many aspects ಇರುತ್ತೆ.
Obliged.
Yes. ಕೃಷ್ಣಮೂರ್ತಿ ಮಧ್ಯಾಹ್ನ ಬರೋಣ. ಕೆಲವು ಯಾವ ಸೈನ್ ಮಾಡೋದಿದೆ, ಏನಾರ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಇಲ್ಲ ಮಧ್ಯಾಹ್ನ
ಆದಿತ್ಯ ಆಫ್ಟರ್ನೂನ್. ಒಂದು ಲಾ ಇನ್ ಎ ಚೇಂಜಿಂಗ್ ಸೊಸೈಟಿ ಬೈ ವುಲ್ಫ್ ಗ್ಯಾಂಗ್ ಆಫ್ ಫ್ರೈಡ್ಮನ್ ಓದ್ತಾ ಇದ್ದೇನೆ ನಾನು. ಏನು ಎನಾರ್ಮಸ್ ಡಿಸ್ಕಷನ್, ಎಷ್ಟು ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆ ಲಾಕ್ಕೆ. ರಿಯಲಿ ದಿ ಯಂಗ್ಸ್ಟರ್ಸ್ they should really read that. ಏನು ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆ law in a changing society. Similar book is written, Law in Social Change, by our professor Ishwar Bhatt. ಅದು ಚೆನ್ನಾಗಿದೆ. Keeping like Amartya Sen wrote the idea of justice, keeping in view John Rawls' justice as fairness. Similarly, Wolfgang Reitman's book, Law in a Changing Society, he had kept it in his view. I feel like that because I read that book also. He has also written in Indian context.
Bentham said that the law will react to society. The law will reflect the will of the society. And
Even Dicey, public law and public opinion in 18th century England. That's true.
And the other aspect, my learned friend was arguing on DRT, is that hard cases will always make bad law, which since 1837 the US Supreme Court has been quoting. If
Always.
the money is not coming back to the source,
What should happen to the national economy? That's true.
It has to keep it.
When we argue for debtors, we will stand in the shoes of the debtor. When we argue for the creditor, then people will accuse that you are like a Jew. That is how it is man's. Therefore, Montesquieu says, it is only interest of the individuals that prompts them to think and act. That appears to be sensible. ನಮ್ಮ ಸೆಲ್ಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಮೇಲೆ ನಾವು ನಿಂತಿದ್ದೇವೆ ಅಂತ ಹೇಳ್ತಾನೆ ನಾವು. Bentham's theory of legislation and morals, what great works there. He wrote the first book, a fragment on the government, when he was not even a major. He sent that book to Lord Chancellor. Lord Chancellor asked, what is the age of the author? He said 18 years. I don't read such books. Such books are fit to be shipped in the, to be given to the fools, ship of fools. ಅಂತ ಹೇಳಿ ಕಳಿಸ್ಬಿಡ್ತಾನೆ ವಾಪಸ್. ಅವಾಗ Bentham comes back to Lord Chancellor and asks, Chancellor, I have a small question to ask. A veterinarian spends a few minutes with the sheep, and the shepherd spends whole of his life with the sheep. Who knows better about the sheep? Then Lord Chancellor grabs that book, reads it, appreciate that. This small book, fragment on the government. Thank you.
ಫೋನ್ ಮಾಡಿ.
Sir,
31 ಕರೀತಾರೆ. 31
Sir, ರಾಘವೇಂದ್ರ ಸರ್, ಇಲ್ಲಿ 2 weeks ಅಂತ ಕೊಡ್ತೀರಲ್ಲ, exact 2 weeks ಗೆ ಬರುತ್ತೆ.
Yeah. Okay. I have no idea.
First, this is an company petition in which the company petition was allowed. OSA it is filed, they have taken a stay, but I have filed this to vacate my stay and the matter may be heard. And repeatedly, they have not been seeking adjournments. I'm ready to argue the matter as per your lordship's convenience. But this has been happening repeatedly unless a date is fixed or something as a last chance. Because if you may see the order sheet. A date can be, a date may be fixed. One date, a date will be better. 15th, March obliged.
And I was told that Mr. Raguraman may appear in this matter.
The appellant to come and argue.
Obliged.
Annamalai.
For
My
adjournment,
lords.
2 weeks time, my lord.
My lords, one submission, my lord, in serial number 40.
40.
My lords, along with this STA 20/2022, there are two more STAs of the same company.
Call this matter.
Same petition.
Along with the STA number.
18/2022 and STA number 19/2022.
Okay. Week after next. Yes.
Lord, serial number 41. I pray for 2 weeks time, my lord.
Yake.
My lord, Mr. Shankar Senior Counsel is appearing in this matter, my lord. Today he is out of session.
All right, 2 weeks.
My lord, the interim order may be extended.
Interim order to continue for only 2 weeks. Yes.
Much.
That's I appear for the petition in this case. My lords, in the connected matter which is kept below, the matter has been disposed of in the same terms, my lords, this petition. My lords, writ petition number 42245 of 2019. The DD file is kept below along with the file. The question on validity of Karnataka Land Grabbing Act, my lords, is challenged. Adralli, my lords, the act is held constitutional, my lords, in one writ petition number 47747 of 2017.
Arvind Kumar Sahib.
Arvind Kumar Sahib. Subsequently, in view of the same, my lords, the writ petitions are disposed of.
Learned counsel for the petitioner submits and learned advocates appearing for the other side do not much dispute that the subject matter of this petition is substantially similar to the one in WP number 42245 of 2019 KLGP between Basavaraj and others versus state and others, disposed of by a coordinate bench of this court, wide order dated 4 April 2022. First, next paragraph. Another coordinate bench of this court in the case of so and so. In writ appeal number so and so, between so and so, disposed of on such and such date, has observed that where a particular relief is granted to a litigant, similar relief cannot be denied to other similarly placed litigants unless derogatory factors are demonstrated. First, next paragraph. Noor madam in view of the above, this petition is also disposed of
My lords, I may be permitted liberty to raise all contentions before the LGC court.
In terms of coordinate bench order dated 4/4/2022, reserving same liberty to the petitioners herein. Petitioner herein.
Petitioner here, sole petitioner. Oh, my lord, there was a coffee plantation land grabbing court in the Tegibeco and there was a discussion of the government. That is so that I will raise it before the LGC court.
All contentions are kept open.
So grateful.
Okay. Next.
Appear on behalf of respondent.
Senior in in other court, my lord, kindly have it and tomorrow.
In matter.
Some, my lord, what had happened, my lord, DRT, my lord, they filed an application for the DRT. DRT, my lord, dismissed the application pursuant to that, my lord, they.
Application for what?
My lord, what had happened, my lord, I filed the original application before DRT under section 19. My lord, in fact, I initiated action also under section, my lord, DRT, under surface provision. They, my lord, they filed an application, they filed an original suit before the court immediate below, that is before the civil court. And my lord, the civil court dismissed the application, the OS filed by my lord, the petitioner, in view of my lord, Order 7 Rule 11, Red section 34 filed by, at the instance of bank. My lord, that has been filed before, that appeal, my lord, has filed before this honorable court. And this honorable court, my lord, remanded the matter back to my lord, the civil court. Pursuant to my lord, the civil court is my lord, that OS is my lord going on. And bank initiated two, my lord, procedure. One is, my lord, original application under section 19, and one, my lord, under the Surface Act. My lord, Surface Act, my lord, in view of, my lord, the matter is pending before the civil court, my lord, we are not, my lord,
pressing it.
Proceeding. Only before the DRT, my lord. In fact, my lord, we have filed the original application in the year of, my lord, 2015, my lord, we have adduced the evidence. When the matter came, my lord, at the stage of, my lord, orders, they filed an application before the DRT stating that, my lord, the matter pending for the civil court, therefore, civil court, DRT should not conclude the proceedings. And my lord, the application rightly rejected by the DRT. In view of, my lord, the DRT filed in the year of 2015 and they filed suit subsequent to, my lord, the filing the suit before the DRT. DRT dismissed it. That, my lord, approach, my lord, they preferred an appeal before DRT. DRT also, my lord, rejected, saying that, my lord, the DRT application filed by the bank is first. And my lord, the OS filed by, my lord, subsequent to, my lord, filing the original application by the bank. That, my lord, order before SL before this one.
That section 10 of CPC will not be applicable at all. It will be applicable in their favor. That what suit should be halted actually.
That's all DRT had.
DRT said that way.
Please, my lord, section 10.
In the said suit, my lord, we are taking contention. Our says forged signature, taking this forged signature, extended the loan to the original.
That contention you urge before the DRT will permit you.
That not permitted in the DRT. We also.
I don't know.
We'll say that now. All contentions which you are raising, including fraud, forgery, fabrication, shall be considered by the DRT.
That application also rejected. We filed application for cross-examination.
Now we will say that. And cross-examination also will permit. First case.
Time bound manner within 3 months.
That's on the 6 months.
3 months.
Tomorrow, my lord.
In fact, matter portion for orders by DRT. We have conclude our evidence. We have pleading is completed everything. In meantime, my lord, they approach this honorable court in the vacation time, and they said, "Matt, tomorrow the DRT is going to pass an order." That is the reason this honorable court shown limited diligence says that next date of hearing there's an interim order. It is continuing from time to time. Have to record more than.
Call tomorrow for further hearing. Fraud fabrication ground and togobeko. Permit you. Cross-examination. Fraud fabrication idre cross-examination allow madlebekaguತ್ತದೆ. That also will grant you. It is agreeable.
In the written statement.
Fraud fabrication iddaga.
My lord, if my lord says, my lord, within 3 months all the proceedings, my lord, DRT is a summary proceedings. Basically, my lord, cross-examination.
Summary proceeding does not mean the ground of fraud fabrication shall not be taken.
Police also filed charge sheet.
My lord,
police also filed charge sheet, my lord. Police are investigated the And also in charge sheet, they are also bank officials also involved.
ಇಲ್ಲ ಇಲ್ಲ,
Maybe
ಇಲ್ಲ,
charge
no
sheet.
charge sheet. I made a submission before.
ನಾಳೆಗೆ ಇಟ್ಕೋತೀನಿ, ನಾಳೆ ಬರಕ್ ಹೇಳಿ.
2:30.
2:30 ಬರ್ತೀರಾ?
ಅಲ್ಲ, ಎನಿ ಟೈಮ್ ಇಲ್ಲ.
ಅದು ಯಾರೋ ಒಬ್ರು ಇರ್ಲಿಕ್ಕೆ ಹೇಳಿ. 2:30 ಪಾಸ್ ಔಟ್ ಮಾಡ್ರಿ.
Grateful, my lord. In fact, my lord, they filed a return statement. They are agreed in respect of registered mortgage executed in favor of the bank.
In the written statement,
So,
it said.
agree ಮಾಡಿದ್ದಾರೆ. They say that, my lord, subsequent announcement, I have not given my consent.
Okay, ನೋಡೋಣ ಬನ್ನಿ, ನಾಳೆ ಮಾಡಿ.
Grateful.
ಅವ್ರು ಬರ್ಲಿ, ಯಾರೋ ಸೀನಿಯರ್ ಏನೋ ಹೆಲ್ಡಪ್ ಆಗಿದಾರಲ್ಲ.
Kindly extend the interim.
Entry order to continue.
Till tomorrow. Grateful.
Till day after tomorrow. Call day after tomorrow. ನಾಳೆ ಬೇಡ, ಯಾಕಂದ್ರೆ ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಬರ್ತಾ ಇದೆ.
Grateful.
ಎಲ್ಲ ಮುಗ್ದೇ ಹೋಯ್ತು. ಹಿಂಗಾಗ್ತದೆ ನಮಗೆ. ಎಷ್ಟೊತ್ತಾಗ್ತದೆ ಅಲ್ಲಿ ಆ ಕೋರ್ಟ್ನಲ್ಲಿ?
Half an hour ಮೇಲೆ.
ಹಾಫ್ ಎನ್ ಅವರ್. ಆಯ್ತು ಬಿಡಿ, ನಾಳೆ ನಾಡ್ದು ಬರ್ರಿ. ಹೌದು, ಜಡ್ಜ್ಮೆಂಟ್ ಕಳಿಸಿ ಅವ್ರು ರೆಡಿ ಮಾಡ್ಬೇಕಲ್ಲ. ಬಟ್ ಅದ್ಯಾವುದೋ ಒಂದು ಮ್ಯಾಟ್ರ್ WP ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿ ನೋಡಿ.
But the validity has once challenged in the. ಮೂವತ್ತರಿಂದ ಅಷ್ಟು ಬೇಗ ಬಂತು. 33 ನಡೀಲಿಲ್ವಾ? 33 ಜಾಸ್ತಿ ಹೊತ್ತು ನಡೆಯುತ್ತೆ ಅಂದ್ರು. ಸಾಹೇಬ್ರು ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ ಪಾಪ. ಟ್ಯಾಕ್ಸು ಜಾಸ್ತಿ ಬರ್ತಿಲ್ಲ, ಬರೀ ರಿಟ್ ಜಾಸ್ತಿ ಬರ್ತಿದೆ. ರಿಟ್ ಅಲ್ಲಿ ಜಾಸ್ತಿ ಹೊತ್ತು ಆಗಲ್ಲ ಅವ್ರಿಗೆ, ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ರು. ಸರ್ 27 ಅಲ್ಲಿ ಅದು ಅನೂಪ್ ಅವ್ರ ಹೆಸರು ಹಾಕ್ಬೇಕಂತ. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ನಾನು 41 ಬರ್ತಿತ್ತಲ್ಲ ಅಂತ ಓಡ್ ಬಂದೆ, 42 ತಗೊಂಡೇ ಬಿಟ್ಟಿದ್ದೆ.
$33 was adjourned.
53, the other side wanted that. He's like, I'm ready. Where's my love?
I just heard 32 and 31.
ನಿಮ್ಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗಲ್ಲ ಈಗ